Okay, good morning everybody. The time is now 10 o'clock and the inquiry is open. My name is Owen Woodwards. I am a Chartered Town Planner and I've been appointed by the Secretary of State to hold this inquiry. First of all, can everybody hear me? I think we all have microphones and I think they can be used simultaneously. So I think you can just have yours on throughout the course of the inquiry. Obviously, we'll if there's feedback and issues, we can just deal with that as it happens. That's okay. Was that you just checking that they can hear on the live stream? Good. So yes, so people can hear on the live stream as well. So thank you for that. Firstly, if I could just please everyone just double check that their phones are off or on silent, please. Now, in terms of the room layout, is everybody happy with the layout of the room? Okay, thank you. As you can see, we are live streaming today, so that and for the rest of the week. Oh yes. I think as long as we can hear you, I think that's probably the most important thing. So where is the? Oh, so is that because you just needed to be here at the beginning and that's all? Okay. Okay. All right. Thank you very much. If we have any complaints, we can maybe look at moving the room around. So breakout rooms. I have my breakout room. Do the parties also have breakout rooms they can use?
We do. Thank you very much.
Okay. Thank you. The toilets are just out there towards the lifts. If I could turn to the council, are there any fire alarms planned today in particular or this week?
Not that I'm aware of, sir. I can check on that. Mr. Duggan, who instructs me, is coming back, so I'll have an answer to that in a moment. Okay,
thank you. And also the fire exits, if you know that as well, or could just find out, please. Okay. I can see the fire exit sign there, but then we are on the third floor, so if we just have the directions for... Thank you very much. So the clock, I'll be using the clock on my computer, which is pretty much the same as the one on the wall as well, so it's 2 minutes past 10. Do we know if we can leave documents in the room overnight or in the breakout rooms? I'm assuming yes to the breakout rooms, but I'm not sure about here.
That would be my assumption that it's okay in the breakout rooms. I don't think I'd be comfortable leaving documents here. But again, that's a matter that I can check with Mr. Duggan. Obviously, the building is locked overnight, but far safer in the breakout room than here.
Okay. All right, thank you. And also, we'll come on to this when I get onto the programme, but there are some issues on a couple of evenings in terms of having to vacate this room, so I think that answers the question as well. Okay, thank you. Does anybody have any questions about housekeeping matters before I move on?
I don't think so, sir. There's only one point that may be helpful just to raise, which is that I think the time estimate that I've included for the cross-examination of the appellant's flooding expert, Mr. Whittingham, is likely to be excessive. Okay. I don't think that I will need as long as that. I suspect I may not be much longer than an hour. So that's one side of things.
Okay.
But I suspect I may need a little longer with Mr. Lane. And the reason for that is I'm intending to pick up most of the issues of flood policy with Mr. Lane, who I think is the proper witness for that, with the effect that there isn't quite as much to deal with in terms of the extent of flooding between the experts.
Okay, thank you. I'm going to come back to that when we get to programme, but thank you for highlighting it now, because there has been suggestions from all sides that it might be slightly quicker on some aspects.
I think that's basically what I'm saying.
Yes.
So, yeah.
So we'll come back to when we do a programme, but thank you for highlighting that now.
So just on housekeeping, just to check, you received rebuttals, did you?
Yes. So I will be coming on to documents and things. Yes.
See, sir, just before we do go on, I see that Mr. Duggan's now here, so we could ask him those questions about
Okay.
Fire safety, just so that you don't have them on your mind.
Okay, yes, thank you. Sorry, yes, I asked about if there are any fire alarms planned and also the fire exit routes, please.
Sure. So there are no fire tests planned, and the inquiry will notice that there's an emergency door just over the back there, which takes you to a external staircase and out of the building to a car park, and you stay in the car park.
Okay, thank you very much.
And then the matter of your documents, leaving them in your room, was the other issue that I think Ms. Duggan can probably help you with.
Yes, are we? Do we have the rooms for the whole week? Our breakout rooms.
You do.
Mhm.
One thing that I would just highlight is that this floor is publicly accessible,
Okay.
like lots of other areas of council. So if you left something valuable in the room overnight, because the room's not lockable, I'll caution against it.
Okay.
Not laptops.
Okay. Well, I'll let every individual make their own judgment on that then. Thank you. Okay. So next, I'd like to deal with appearances. Firstly, I'd just like to highlight that Deborah Board, who is an inspector, is attending today to observe. She sat at the back there, but she's not taking any part in the inquiry itself. She's just observing today. And now I will now turn to the participants to take the names of those who wish to speak, and I'll start with the appellant.
Thank you, sir. My name is Guy Williams, King's Counsel, instructed on behalf of Gladman Developments Limited. And sir, in terms of witnesses, I am calling 4 witnesses, and in the order in which they're currently scheduled, that's Ian Grimshaw, dealing with landscape matters, Andrew Newell, dealing with ecology matters, Colin Whittingham, dealing with flood risk, and Laurie Lane, dealing with planning.
Thank you very much. And the council.
Very good morning, sir. My name's Rowan Clapp. I'm appearing on behalf of Swale Borough Council. Just moving down the table to my left sits Mr. John Etchells, Director, sole employee of John Etchells Consulting. He's our landscape witness. To his left is Martin Carpenter, the Director at M-Plan. We're dealing with planning matters. Further down the table is Miss Kathy Fishenden, who's a planner at M-Plan. She's not giving evidence, but she's a member of our team. And we have one missing member of the team, Mr. Hartwell, who is a flood risk consultant at JBA Consulting. He's coming this afternoon to deal with flooding. But of course, that evidence begins tomorrow.
Okay, thank you. I've taken all the details in terms of qualifications and things from the relevant proofs. So I will take those as read, and you can tell me if that's wrong at some point during the course of the inquiry, because obviously I'll need to list that on the decision notice. Yes. Thank you. We also have 2 Rule 6 parties today for this inquiry, so I will now turn to them. Firstly, the Faversham Town Council, please.
Good morning. I'm Peter Cook. I'm a Town Councillor for Priory Ward, which embraces the appeal site. I've been asked to represent the Faversham Town Council. Also, the Bray brothers, who own part of the land which has been outlined in red. They've asked me to speak on their behalf. Also present is Francis Beaumont, who will, for the Safeham Farm Group, who will be speaking on the ecology.
Okay, thank you. Are there any other interested parties here today who wish to speak? Yes, sir.
My name is Stephen Atkins. I represent the Faversham Society. I'd like to make a plea by the way of a statement, which I will read out to the inquiry.
Okay, thank you. So provisionally, I would like to hear from, finish my opening remarks myself, and then hear the openings from the other main parties, and then hear from you, sir. Is that okay with you? Essentially, that should be later on this morning.
Sorry?
Would it be okay to hear from you later on this morning after we've finished the openings?
Yes.
Okay, thank you very much. And anybody else? Okay, thank you very much. So just so everybody is aware, I've read the consultation responses both to the original application and for the appeal. Mr. Atkins, when you speak, I will ask if you wish to accept questions from the parties or myself or not. It's completely up to you if you wish to allow for that. But if you do allow for questions, then it adds weight to that I can give to the evidence you provide, because then it's been tested as part of the inquiry. But we'll deal with that again when you stand up for your speech. Thank you. Are there any members of the press? Okay. And as we've already discussed, we're live streaming the event, so that's being recorded for the duration of the inquiry. Thank you. So I'm just going here through the things I need to cover. Firstly, thank you to the council for providing the notification letters, the distribution list, and a map of where the site notices were placed. So thank you for that. That's all been confirmed. Also, just in the interest of full disclosure, there was a case management conference held on the 14th of October, which was run by myself and was attended by the Appellant, the council, and the Rule 6 parties. These are a common feature of inquiries, and they discussed the procedure for the inquiry, but the merits of the appeal were not discussed. Okay, so the appeal. The appeal is made by Gladman Developments Limited against a decision by Swale Borough Council to refuse planning permission for the erection of up to 250 dwellings, including affordable housing, public open space, landscaping, SUDs, and a vehicular access point. It was made with all matters reserved except for access. This application was refused permission on the 20th of June 2024. I'll just pause there to make sure that's all correct. So the appeal site is around 14 hectares and lies outside of, but adjacent to Faversham, and it comprises fields in agricultural use. And as I've just described, it's proposed to develop the site for residential development and associated access from Ham Road. We have two drawings that are formally connected to the application, which is the location plan, reference D964.01.001A, and then the access arrangement, which is reference 17277H-01 revision P6. And I think that's all correct. It was confirmed at the conference. We also have illustrative material, a master plan, an open space plan, a development framework plan, and of course various other supporting documents and information. And of course we'll be turning to those as required throughout the course of the inquiry. Planning policy. So we have the development plan, bearing fruits 2031, the Swale Borough local plan, which was adopted in July 2017. The statement of common ground sets out the relevant policies, and I'm sure we'll be turning to them as appropriate throughout the course of the inquiry. Then we have the Faversham neighbourhood plan. Now, as of the conference, I was told that there was going to be a referendum held on the 21st of November. So I just want to turn to the council now to understand what happened with that referendum, please.
It was passed at the referendum. But yet formally made.
Do we know what the timetable is for that?
I'm afraid I don't. Do you know?
If I may, sir, the referendum was successful. In terms of adoption, I'm advised by my policy colleagues it's likely to be early next year, not before Christmas. Okay.
Well, we can pick that up as we go through the course of the inquiry with the planning and other witnesses. But the important thing was just to confirm the factual position as part of the openings. So thank you for that. Does that require any further documentation to be submitted, or is the plan itself exactly as already in the documents? Okay, thank you. If I could maybe ask, just for completeness of my records, if maybe there's committee minutes or something similar that just confirms the referendum position, please, just for the paper trail. Okay, thank you. Mr. Williams, do you have anything to add on that at this stage?
Yeah, that's our understanding as well.
Okay, thank you. We also have an emerging local plan. Now, as of the conference, this was Reg 18 consultation expected to be undertaken second quarter of next year and then adoption in 2027. Is that still the case? Okay, thank you. So in terms of documentations, just to confirm that in the lead up to the inquiry, I've received and of course read the proofs and the rebuttals from the main parties and the Rule 6 parties. I've also received the SIL compliance schedule from the council, so thank you for that. We had the very recent Secretary of State decision on land adjacent to HMP Garth and HMP Wymott, which was handed in by the appellant, has become CD 11.1. We had 3 statements of common ground, a general one, a landscape one, and a flood risk one. I did also receive some further submissions from the Town Council and Save Ham Farm, including highway pinch points and air quality information. Now, that information was accepted and I believe has been shared round to the parties. Obviously, say if you haven't seen it, Mr. Williams. But then I also, in the last couple of days, further evidence was submitted by Mr. Cook. And I didn't accept that, but I would just like to know to understand a bit more about what that is, Mr. Cook, and just so we know where we stand, please.
Yes, I looked on the council's website and discovered that TEP had made comment on our proof. I hadn't received that directly from them, when I heard that you were refusing to accept my response to that, which was drawn up immediately, I noticed it. I contacted the planning inspectorate and was told that it had been copied to me by the appellants, and my name appeared on the thing. I've checked my computer, including junk. I didn't receive it. That's why I didn't respond at the time more expeditiously than I did.
Okay, thank you. The nature of this evidence, is it something that you would be comfortable in dealing with in terms of the questions that you ask of the relevant witness, or is it more involved in that and it's more of a document that needs to be submitted?
It would be good if it could be submitted as a document, but I can probably cover it in cross-examination.
So this is flooding, you say?
No.
Oh, sorry.
It was TEP started off. They looked at the Save Ham Farm submission on ecology, and then they moved into commenting upon other matters that I had commented on in my proof, which was more wide-ranging. So they were making reference to drainage and other things, although obviously TEP aren't responsible for the drainage strategy for the appellants, but nonetheless they made those comments. So I was responding to that because I thought that their comments were, they made comments which were fallacious.
So I'm just trying to understand in terms of broad topic areas where these fit within. So would it be covered in the ecology roundtable session and the flooding and the planning?
It mainly within the planning and the ecology.
Okay. So I think in terms of the planning, I mean, the planning we're not even hearing until later this week. So I don't think I'd have any particular concerns about accepting your comments now, because there would be time for the parties to review them ahead of the planning. Ecology is slightly more complicated because we're planning on discussing that this afternoon. Yes, just Mr. Williams, just your thoughts on this first, please.
So we haven't received the material. We have asked for it to be resent so that we could consider it. Instinctively, we would try and accommodate it in the inquiry programme, but we can't really tell you whether that's possible until we've seen it. So if Mr. Cook, perhaps outside of the formal inquiry sessions, if we could just spend 5 minutes with Mr. Cook to understand what the material is and find a way of making sure we have it, then we can update you. But our preference would be to try and have it accommodated so that we can deal with it within the current timetable.
Okay, thank you. If it's acceptable, Mr. Williams, I might slightly cut through that then. I think I might just accept it now, because that gives us more time in all the breaks we have today before the Ecology Roundtable session to make sure that I can review it as well as everybody else. Because I think the alternative would be we have to wait to the first break, then we discuss whether or not it's submitted, and then really we only have lunch. So, Mr. Cook, if you can please resend that to the case officer as soon as possible, even now if you can in the background, if not at the first break. And then we will all have time to review that ahead of the Ecology Roundtable session.
Yes, can I just say, when I sent my first submission to Amy Peckham at the Planning Inspectorate, I said to her that I was only submitting it to her for distribution unless she notified me otherwise. She didn't notify me otherwise, so I have generally just submitted stuff to the Planning Inspectorate for transmission onwards to the other parties.
Yes, so yeah, that is a general approach.
Why they didn't get it.
So in the interest of expediency, I will quickly just send an email now myself. And then hopefully that will come around during the course of the openings, and then we will have longer to look at it. I will make sure that all parties have long enough to look at this information ahead of the roundtable session on ecology to make sure that nobody is disadvantaged in any way. So that might mean having a longer break than normal, for example, mid-afternoon. But we can deal with that, I think, better once we've actually read the information. Okay, thank you. And then in a similar fashion, Francis Beaumont, you submitted information regarding air quality and highways. So again, if I could just understand a bit more about that, please, and how it builds on the information I'd already received and accepted, which was the pinch points and the other air quality information.
This was information I sent because of the deadline for the timing, and I sent it on behalf of Mr. Cook or myself. One or other of us will be dealing with that. I suspect it will be Mr. Cook actually, but I'm happy to do that myself as it is an issue we've raised.
So how does it go beyond the information that I've already accepted, which was the pinch points, and there was a map of the road network, and there was air quality information?
Yeah, well, I will be mentioning that in my submission.
Okay.
I don't know what the procedure is for showing that here, but it's here for people to see if we can show it in some way.
So is this additional to that information I've already accepted?
It's certainly backing up what we said already. It's not, I don't think it's new information, but
Okay. Yes, Mr. Williams, your thoughts on this?
I'm not 100% sure what's being referred to be honest. We did receive some additional information from Mrs. Beaumont, but I'm not sure whether Mrs. Beaumont's now talking about that or something else. And again, I'm not trying to be unhelpful, but it would be really helpful to have a list of what documents it is that Mrs. Beaumont intends to refer to, and then we can double check that we've got all of that, and whether you have, sir.
Yeah, so what I already have, Mrs. Beaumont, is a map called Figure 15 showing NO2 in Faversham. I have a map of an air quality management area number 6 along the A2. I have another map with various pinch points written in hand on an OS map, it looks like, in Faversham for highways. And then I have a photograph of a document written by the Faversham Society talking about road traffic and air pollution in Faversham. Firstly, Mr. Williams, is that the information that you've received as well?
I'm not 100%
Okay.
sure, to be honest. We'd have to double check that.
Hopefully you have, 'cause I did actually formally accept that via my case officer a couple of weeks ago. Mr. Clapp, have you received that? The air quality and highways pinch point information. Okay, there might have been a miscommunication then internally. So I'm just waiting. They're talking. Yes. So, Mr. Cook, does it go beyond that as far as you're aware?
I haven't actually seen it, so I was just checking. I understand that it was sent in to the planning inspectorate, and Ms. Beaumont thought that she'd copied it to me. If she did, I hadn't.
So those documents that I just listed, Ms. Beaumont, are those? So I'll give you a moment to talk to the council officer. So those documents that I just listed, are those the documents that you are submitting, or is there further information beyond that?
No, no further.
Okay. So I think what's happened is a miscommunication on some level internally, because I'd already accepted these because they came in a couple of weeks ago. So I think the easiest way to resolve this is just simply to ask that they now be sent around to everybody. And then if it can be picked up, probably with the planning witnesses, because it's general planning points. Is that acceptable to you? Thank you very much. So I'll just make a note to make sure that's sent round probably during the first break, because we don't need to deal with that immediately at the inquiry.
That's fine, thank you very much. And we'll work on the basis that that's going to be dealt with in the planning sessions, because that does give us a little bit more time.
If for some reason either side or any party here thinks otherwise, then obviously please do raise it and we can discuss how to deal with it moving forward. Okay. Something else to discuss, the potential new framework on Thursday.
You said Thursday first, so that's...
We don't have any special hotline to MHCLG, unfortunately, so I know no more than you. But there is obviously the potential that there'll be a new framework during the course of this inquiry. I was thinking about this yesterday. I'm not sure how much mileage there is in talking about it now, because it's potential and we don't know either if it is going to be released or what it says. But it is something that obviously could be quite important. Yes, Mr. Williams said you had a thought about how we may or may not deal with it.
Well, I had a thought, and we discussed it yesterday. And speaking entirely for myself, I would rather it came out during the inquiry than the day after we'd closed. But I agree, for the time being, I think we keep going. If on Wednesday it becomes announced, for example, that it's going to be released at 10 o'clock on Thursday morning, then it would probably be sensible to take some time to read it and then think about how we proceed. But until we actually have a document, I'm not sure it's worth holding things up.
Mr. Clapp?
I think that's right, sir. I think we can certainly deal with the technical evidence without any hold-up, as my learned friend says. And we'll have to take a view depending on what, if anything, happens on Thursday.
Okay, and Mrs. Cook, firstly, are you aware of this? Because obviously you're not a planner. Essentially, there might be a new national planning policy framework released this week, and if it is, that might, for obvious reasons, have an influence on the inquiry, because it will change the national planning policy background. As you've probably just heard, I think at the moment there are too many unknowns to make any decisions about how we deal with it now. but it's likely that if it does come out this week, at that point we're going to have to discuss how we proceed during the course of the inquiry. We do, of course, have next week, so it is possible that it can just be dealt with quite seamlessly. But I think talking about it too much now is a hostage to fortune, really, because we don't know what it's going to say. Do you have any questions in general about it?
No, I don't. I hadn't got anything planned for the weekend other than working on this anyway, so...
Okay, thank you. In that case, I think we leave it there for now, but I think we're all aware that it probably is going to have to be dealt with at some point during the course of the inquiry. And of course, I'll make sure that everybody is, no one is prejudiced by it being released. Okay, thank you. Does anybody wish to submit any other evidence at this point? Okay, thank you. In terms of hosting the evidence, so the council set up a website, and when I checked yesterday it was working, and then when I checked 5 minutes before walking in here it wasn't working, and I wasn't sure if that was just the Wi-Fi or if there's something else that's struggling, because I could open other websites.
I can certainly have someone check on the website to see whether it's still running, sir.
It does have a ring of familiarity in that Inspector Prentice, I did an inquiry here last July, and Inspector Prentice struggled something to do with the PIN security system on the...
Okay.
I don't know whether that... I don't want to be alarmist in any way, but that does ring a bell.
Can I ask, can you all access the website, please? Can I just check on that? Because I might be able to work around it because I've saved all the documents onto my computer. So if it's just me, we're probably okay. Yes. But obviously I'm thinking about people potentially watching online who'd want to...
Sir, it's working for me and my colleague on the second floor.
Okay. That's promising. If I can maybe have somebody who isn't in the council check as well, just in case it's a more general firewall issue. I'll just give you a moment now to do that.
I don't know when you're experiencing the problem in the login. I'm having trouble having clicked on find planning applications as well or a council.
Yeah, so I can get onto the website, the general website, and then it's the planning search that I can't do.
Yes, that's
Okay.
as well.
Is it something to do with us being on a non-council computer but on the council's Wi-Fi? Because it did work yesterday when I checked in my hotel. And Mr. Cook and Ms. Beaumont, can you access the documents?
I have...
However you're doing it, do you have access to the documents?
Yes.
Okay.
Can you get on their website?
Okay, so I think we'll proceed for now on the basis all the parties in the room can access the documents. But I think what I'll do is I'll check when I'm at my hotel again this evening, and if I can access it again there, then that gives me comfort that people in general can. And if maybe I can just ask if people double check during the course of today, just to see if it starts working again, please.
I just ask, sir, on the live stream, is anyone from the council monitoring the live stream in terms of if someone were listening and wanted to make a comment, for example, yes, we can access the documents?
Yes, that's a good point. Obviously, we had the people there. They've gone away now.
I'll just check a colleague downstairs who's monitoring it.
Thank you.
Okay, thank you. So, is there like a chat function or something similar for them to directly ask questions? Did Mr. Prentice find a way around this, by out of curiosity?
Hard copy.
Well, I've been caught by this before, so I always now download everything to my computer, so at least I can access things.
I think Inspector Prentice had already downloaded the majority of the core
Okay.
documents. It was just those that were either bigger or less regularly used. But if there's anything we can do to assist, we do have a hard copy of all the core documents. So if, for example, anyone who was being asked questions or you, sir, didn't have a copy and needed it, we can make that available as and when.
Okay, thank you. Okay, I think to avoid this becoming too much of a delay, I'll double check myself later on today in terms of access outside of this room. If I can ask the council just to make sure that people online, if they do want to ask questions about this, can access the documents. Because obviously it is important that they can. And also they are able to let you know if they can't. And then in terms of documents that are added during the course of the inquiry, if I can ask that those are electronically sent to my case officer, because she can then email it to me and I can receive them that way.
So if I may just intervene, I've just connected to the portal using my phone link, and it's up and running.
Okay.
I've been contacted by 2 people who have done the same thing from outside the council using their phone, and they're able to access the website and the documents.
Okay, so that gives me comfort that people can access the documents. So that's the important thing. So thank you for that. It looks like I'm going to struggle personally. So like I say, for inquiry documents, so they can be emailed, and then I will be able to access them via my emails rather than via the website. However, I would like those to be uploaded to the website as well. So can I just check, is there somebody here who's been given that task?
In terms of things like the referendum information, for
Yes,
example.
and just other documents that just get produced during the course of the inquiry. Yes.
So yes, and it would be shared with the PINS casework unit, and we also have an appeals team that would upload it to the website.
Okay, thank you. And in terms of managing those, my approach is to state when a document is an inquiry document and give it a number. And then I tend to agree at the end of each day with the main parties what those documents are, just to make sure that we're all on the same page. So,
So would you coordinate that at the end of each day, or are you wanting it done as we move through the inquiry?
at the very least, I'd like them uploaded at the end of each day. If it is possible just to do it as they're submitted, then that's great in terms of adding it to the website. But I mean, the quicker the better, because the easier it is for people to access, the better. Okay, thank you. Any other questions about documents? Okay, thank you. Okay, so the next thing that I wish to cover is main issues. So there were 3 reasons for refusal. The third reason was in relation to the effect of the proposal if a Section 106 was not signed. Now, a draft 106 has since been produced, and we'll be having a roundtable session on that towards the end of the inquiry. So at the moment, I'm proceeding on the basis that that falls away. Although I do note that there are some areas that aren't agreed yet in red, which I imagine we will pick up at the roundtable session, unless I'm told otherwise.
That's right. So my understanding is that there's an agreement that the 106 can deal with the third reason for refusal. There are 2, I think, areas in which you're being asked to choose as to the particular issue. For example, affordable housing and air quality, as to whether what we have proposed is acceptable or whether the council's proposal is acceptable, and there's a blue pencil that would enable you to choose between the options. But I think that otherwise the drafting on either option is agreed to be effective, and there is a document that's with the council which hasn't yet been sealed because we're awaiting the session on the 106 in case there's anything that comes out of that. And then depending upon whether there needs to be a change. I think there might be some sealing date issues at the council affected by Christmas, which might mean we may need to ask for a period of time in which to submit it.
Okay. Well, we'll talk about in the roundtable session. Christmas also has issues in terms of me being able to write my report as well. So they should hopefully work in tandem. Yes, Mr. Clapp, is that your understanding of the position?
So yes, that's the timing.
And Mr. Cook, is there anything that you would like to add in terms of Section 106 at this stage? Bearing in mind we will be talking about it in detail towards the end of the inquiry. And Ms. Beaumont, I note that air quality is one of the issues that is in red, if you like, in the Section 106, and obviously you've raised concerns about that. So we'll make sure that we cover off anything that you need, that you're concerned about, either during the planning witnesses or in the 106 roundtable session. Okay, thank you. Okay, so subject to that, we have the main issues for the appeal, which are, firstly, whether or not the proposal represents an acceptable form of development having regard to its flood zone location and the provisions of local and national planning policy. The second is the effect of the proposed development on the character and appearance of the area, including on landscape character. And the third is whether or not the appeal site is an appropriate location for development of this type, having regard to planning policy and including with regard to best and most versatile agricultural land. But I'm also aware that we do have several other concerns raised by the Rule 6 parties: accessibility, highway safety, air quality, drainage, ecology, and some overlaps between ecology and drainage and how the things interact, and of course the land ownership issues with the Bray brothers. And of course we're going to make sure that we talk about those throughout the course of the inquiry, and those are also important matters in front of me over the next couple of weeks. Yes,
Clear,
Mr. Clapp.
sir, if I may. Reading your CMC note, those three main issues are of course absolutely right. In your note, paragraph 4, you say FTCs raised concerns regarding BMV, but of course, and just to be absolutely clear, that BMV issue was part of the second reason for refusal and is pursued by the council.
Yes, you're right. I think that's probably a mistake in my notes, and I've
It's not
since
a big problem,
then.
so it doesn't go anywhere. It's just to be clear.
Yes, just to reassure you, as I've now written the main issue for the purpose of my opening, I have included that within sort of the council's
I'm grateful.
and the Rule 6 parties' concerns. Okay, thank you. And also there was some information regarding a potentially historic footpath that's been sent through, which again we'll make sure we discuss. And of course, I'm not forgetting that there has been a substantial number of objections from other interested parties. As I've already said, I've already read these. And of course, a large majority of what's been raised will be covered naturally as part of the discussions. And of course, I'm hearing later today from one of the neighbours. In addition to that, although not disputed issues, I do have a statutory duty with regard to heritage because the appeal site lies in the setting of 3 Grade 2 listed buildings and a Grade 1 listed church. So it's just to highlight that I will have to consider that as part of my decision. And also there is the Swell Estuary Special Protection Area and Ramsar. Now, of course, this goes to the heart of some of the issues that the Rule 6 parties are concerned with, and I'll be considering that carefully. I will be the competent authority, so I will have a statutory duty to consider this anyway. And of course, in addition to that, I'll be hearing your particular concerns. And further to that, there will be the overall planning balance, including the applicability or otherwise of footnote 7 of the framework regarding flooding, and potentially to include a heritage balance of less than substantial harm versus public benefits, depending on the conclusions I come to in terms of the heritage aspects. I'll come on to the programme in a moment, but in terms of the main and other issues, does anybody have any comments on the way I've just set them out? Okay, thank you. Conditions. So I have a draft conditions schedule dated the 20th of November, including commentary by the main parties. Now, my normal approach to this is to write my comments on the draft schedule at some point during the inquiry and then use that as the agenda for the conditions roundtable session towards the end of the inquiry. So I'll probably do that at some point this week and then send that through to you all. So I think we've covered the section 106. We'll be coming back to that in the roundtable session. And I've already confirmed I have the civil compliance statement from the council. There was also a Kent County Council document that in effect was a civil compliance statement, or they're not called that. So I've also got that and read through that. And yes, of course, I will allow a suitable amount of time following the inquiry for the engrossed version to be sent through. And I'll be pragmatic about Christmas. Okay, so the programme. Firstly, did you receive my latest draft a couple of days ago?
Yes, sir. Thank you.
So yes.
Mr. Cook?
Yes.
Okay, thank you. So the programme set out is openings this morning, and then, of course, we'll hear from the interested party, Mr. Atkins. We'll see how we're doing with time, but we'll have a lunch break, obviously. And then we've got the landscape roundtable session and the ecology roundtable session. So that should take us through today. We then have the flooding witnesses and then the planning witnesses. And I think from what has been said today and also in emails leading up to the inquiry, it feels likely that the flooding section might be completed slightly quicker than had been predicted. So we'll keep an eye on the inquiry. It might be that we move some witnesses forward slightly to deal with that. Also, in my draft schedule, I have the site visit on Monday, but my gut instinct is we will be able to do that either Friday morning or at some point on Tuesday instead and keep it within the normal inquiry times. But I think I don't really want to speculate on that too much yet. I think we'll know much better where we stand after we've had the flooding evidence. And I am conscious that the framework potentially coming out might scupper any plans to make it shorter. So I think we'll just see where we stand on that. So if I could ask if everybody could just keep Monday afternoon, well, everybody who needs to be on site visit, nobody else, does keep Monday afternoon clear for now. But we'll see where we end up on that during the course of this week. In terms of finishing times, so we have to finish at 1 o'clock on Friday.
So sorry, just
Yeah.
that's an accompanied site visit, isn't it?
Yes, but it would only be the people that need to be on that visit. And ideally, it's not going to be then. It's just, I think now that's really just if the framework throws a spanner in the works, I think that would be the only reason I think we're realistically going to need it. So yes, we have to finish by 1 o'clock on Friday, which I think is going to be achievable fairly comfortably. I also believe we have to finish by, is it 4:30 tomorrow to allow preparation of the room?
If at all possible, sir, yes.
Okay. So can that flex at all to 5 o'clock if, for example, there's somebody just towards the end of their cross-examination?
Yes, of course. Yeah.
Okay, thank you. So we'll aim for 4:30 tomorrow, but knowing that there's slight flexibility. But I think 5 is a properly hard deadline, isn't it, then to allow time?
It's just the streaming and it actually takes quite some time to get it together.
Okay, thank you. And is that the same Tuesday next week as well?
I'll double check.
Okay.
I don't think so, though.
Okay, I've got a note here about that, and I can't now recall where that note came from. But I don't anticipate that being an issue anyway. Okay, does anybody have any comments on the schedule?
No, sir. That's helpful. Thank you.
Okay. So obviously we have cross-examination for the planning and flooding witnesses. We also have some roundtable sessions. For the roundtable sessions, it will be led by myself. And then, of course, it's sort of like almost like a hearing within the inquiry. It's not too big. Sometimes I change the room around or ask people to move around for the purpose of the roundtable session. I'm not really sure that's necessary. It's not a particularly large room. We've got our microphones. Perhaps if I could ask whoever's involved in the roundtable session is in this first ring when they happen, and other people move back. That might be helpful, just so everyone knows who they're talking to during the course of each one. Okay, thank you. Just so you know, my approach during cross-examination, I tend to just ask questions as I think of them. I don't like wait to the end and then ask a series at the end of cross-examination. So just be wary of that. Site visits. So I went yesterday. So I've had a look at the appeal site from public areas. So I have a general understanding of the site and the wider area. As just discussed, though, I'll need to do a formal one. And we can make sure that we agree that time during the course of this week. If I just ask you all to think about who needs to attend, bearing in mind that it's there's very limited interaction with me during the course of this. It's really just to point out things and no evidence will be heard. And also an appropriate place to park, because I just sort of parked in a probably slightly illegally, like the entrance to the field. I don't know if there's a more formal place to park, maybe in the housing development that's nearby. Okay. The weather was atrocious yesterday. I didn't really want to walk any further than absolutely necessary, so I parked right by it.
Depending upon the number of cars that are going, it would be possible to park in the farmyard. I have checked that with Andrew Bray, so he's happy for that. But obviously it's not a car park, so it depends how many cars would be going. I don't know if we could get an idea so that I can just confirm it to him.
If we can park on the road, then I think that's probably easiest, just because there's one less complication in terms of arranging the visits. Yes, sorry.
It might be convenient to park in Upper Brents because that's a good access point to the corner of the site, and there's good car parking there. Upper Brents.
Okay.
I was going to say that it's a narrow lane,
Mhm.
hand road, and you can park there.
I'm just thinking this through. So the next thing I was going to ask is, can all the parties agree a walking route where they need me to go? And perhaps once that's agreed, it would become more obvious where's a good place to park to then undertake the walking route. So if I can maybe ask the parties sort of offline just to confirm that and then come back to me with a final proposal, please.
Sir, if I could, just two things. To confirm that it's the 11th and 17th that they're hoping to get access to the room, to the chamber. And there's just some feedback from members of the public. They can't hear the Rule 6 part, so I'm just going to ask them to come down and sit by a microphone.
Yes, please. Ms. Bowman, if you could just sit down near Mr. Cook, please. Okay, thank you. The last on my list of things to cover is costs. So I haven't received any applications for costs yet. But obviously, if you do wish to make an application, then please do so before we close the inquiry. And I'll revisit that nearer the time as necessary. Okay, thank you. Has anybody got any comments before we move on to the opening statements? Okay, in that case, I'll turn to Mr. Williams. Thank you. Oh. So I'll call this ID1. If I could ask, could you send an electronic copy through at some point, please?
So yes, I understand that's already just been done.
Okay.
And to the Rule 6 parties as well. So, sir, as you've said, this appeal seeks planning permission for up to 250 dwellings, including affordable housing, public open space and landscaping, and associated development on land at Ham Road in Faversham, which I'll call the appeal site. Planning permission was refused by the council, and the main issues that arise you've identified, sir, in the way that you've just described, so I won't read those out again. Turning to the first main issue, which raises issues as to flood risk, the appellant relies on the evidence of Mr. Whittingham in relation to the technical matters of flood risk assessment, and Mr. Lane in relation to the planning aspects of the sequential test. It's established that whether or not a sequential test is required in a given case is a matter of planning judgment for the decision maker. This was clearly stated in both the High Court and Court of Appeal judgments in the case of Wathen Fayed against the Secretary of State, and I've given the reference. As referred to by the inspector in the recent Bailrig Lane decision that was provided with the council's rebuttal, that is a case-sensitive evaluation. Conditions that may be imposed on the grant of planning permission are relevant to that evaluation. In exercising that judgment, regard should be had to the relevant policy context and guidance, recognising that it does not have the force of statute, and the aim is to promote the true practical meaning of the policy in its context, bearing in mind the objectives of the policy maker. Often, it's enough to say that the policy simply means what it says, and that it's the job of the decision maker to apply it with realism and good sense in the circumstances as they arise. Policies are often not rigid, but flexible to allow for and to require the exercise of planning judgment in the various circumstances to which the policy in question applies. The court and the decision maker should have in mind the underlying aims of the policy. And so that's largely a summary of principles relating to policy interpretation set out as per footnote 3 in the Mead Realisations case. And I've tried only to refer to cases that are in the core document, so you have that. There's a considerable amount of common ground relating to the assessment of flood risk, and assessment is the first necessary step for consideration of the sequential approach. The statement of common ground confirms, firstly, the parties agree that analysis of flood risk using the latest on-site ground levels would be appropriate to assess the extents of potential tidal flood risk, and that's the 1 in 200 year event on an undefended basis. Secondly, in relation to surface water, the mapping does not show any off-site surface water flow paths entering the site. Surface water flood risk is shown to be from ponding of water within surface depressions. The original dataset used to develop this mapping date from 2012. The restoration of the site, and therefore the updated ground levels, were completed in 2016. And so the mapping also predates the development of the Goldings, which on it is also shown to be at risk of surface ponding. And so the parties agree that this mapping does not reflect the up-to-date ground contours, and so the outputs of the mapping should be understood in that context. Thirdly, all technical flood risk consultees have been consulted and raised no objection. That is, the Environment Agency, Kent County Council as the lead local flood authority, and the Internal Drainage Board. As such, there's no technical objection on any flood-related matter. In this case, finished ground levels would need to be agreed as part of a scheme to address land contamination across the site. Once the flood risk is assessed, it's appropriate to consider whether or not the flood risk can be avoided by placing vulnerable development in areas at low risk of flooding. In this regard, it's agreed that the Environment Agency guidance is relevant. This is to the effect that a sequential test is required where vulnerable development is proposed on land that will be at risk of flooding when assessed in line with the appropriate design year and allowance for climate change as set out in the PPG. This approach is consistent with the NPPF advice that inappropriate development in areas at risk of flooding should be avoided by directing development away from areas at highest risk, whether existing or future. Where vulnerable development must be placed in such areas, then an exception test is required, which is again based on the vulnerability of the development proposed in those areas. This is all consistent with the PPG approach of assess, avoid, control, mitigate, manage. The appellant submits that no vulnerable development will be in an area at risk of flooding, having regard to the proposed conditions. All of the housing will be located outside of the area of assessed flood risk in the design year. A sequential approach has been followed, which places non-vulnerable development in the area of assessed flood risk in the design year. This is because it's either appropriate for that area, like the open space, or because it's necessary, like the access. The site has been previously worked for mineral extraction and restored so that there is potential contamination, and any remediation exercise would necessarily reprofile the land. As such, any consideration of future flood levels will reflect the levels approved pursuant to the remediation scheme. The access is taken from Ham Road, which is an existing road. The access represents essential infrastructure and will be entirely safe from flooding. It will not be in any future flood zone 2 or 3. No issue is raised by the Council in relation to policy DM23 of the local plan, and it's hard to see why any different approach should be taken as between the appeal proposal and the Goldings, which will in fact benefit in flood risk terms as a result of the provision of the proposed access road. The provision of an access in this location is consistent with the Council's policies relating to tidal flooding and coastal change management, and in turn that policy is consistent with the framework and helps identify that such development is not inappropriate in this location. The planning judgment in relation to the sequential test is reached by Mr. Lane and is set out in detail in his evidence. I don't repeat that. The appellant will submit it reflects a realistic and practical judgment that adheres to the objective of national flood policy, which is to avoid placing vulnerable development in areas at risk of flooding. This is particularly the case in relation to a site where there is a benefit in the remediation of the potential contamination arising from past uses, such that the regrading of the land is an inevitable consequence of delivering that beneficial change. For these reasons, it's submitted that no sequential test is required on this site, and the sequential approach set out within national policy has been appropriately applied. As such, there's no breach of national or local policy, and no clear reason based on the framework to refuse planning permission within the meaning of paragraph 11D1 of that document. Mr. Lane will also refer to the recent Secretary of State decision relating to land adjacent to HMP Garth, where the Secretary of State concluded that a failure to comply with national policy in relation to flood risk including the sequential test, attracted moderate weight against the scheme. Turning to the second issue of character and appearance, here the appellant relies on the evidence of Mr. Grimshaw. There's also a topic-specific statement of common ground. It's agreed that the landscape and visual appraisal of the appellant provides an appropriate level of detail for assessing the impacts of the proposal, and that the method and conclusions are reasonable. And so I've put in brackets the paragraph numbers from the statement of common ground. The site is not a valued landscape, in inverted commas, and it has no local or other designation for its landscape character or quality. The site's character is influenced by the recent residential development to the immediate southwest and west. The level of adverse landscape effects from the development would be limited by other development, the relative lack of prominence of the site, and by the provision of open space and green buffers. The assessment of initial moderate adverse effects at year 1, reducing to minor adverse effects in terms of the impact on the site itself and its immediate surroundings, is reasonable. The landscape effects would be contained within a relatively small area. As to visual effects, it's agreed that the assessment within the LVA Section 8 is generally reasonable, although Mr. Etchells considers some impacts may be overstated. The provision of open space in the eastern part of the site would provide a buffer to views from Faversham Creek, and in the western part would provide a buffer to Ham Road and the listed buildings on its far side. The parties agree that the landscape strategy presented in the design and access statement is acceptable in principle in terms of its scope and layout. There would be some adverse effects on the character and appearance of the landscape of and around the site, and also some adverse visual effects, both broadly as set out in the LVA, and those adverse effects will need to be taken into account in the overall planning balance. In determining the planning application and that balance, the Council considered these residual harmful effects should attract limited weight in the overall planning balance. Overall, Mr. Grimshaw concludes that the proposals would be consistent with the existing character of the settlement edge. The newly defined settlement edge will form a screen to open land beyond the development site. The scheme minimises and mitigates adverse landscape effects and avoids there being any remaining significant adverse impacts on landscape character. As such, the proposal complies with the hierarchical policies within the framework and the local plan that protect landscape of value, and applies a lower test in relation to other non-designated areas such as the appeal site. At the detailed design stage, the layout, design and landscaping of the development can be approved by the Council to ensure the development reflects the local townscape and landscape character. Issue 3 and the question of an appropriate location for housing, the appellant relies on the evidence of Mr. Lane. An important consideration in addressing this issue is the agreement that the Council is unable to demonstrate a 5-year supply of housing land, such that the most important policies for determining the application are deemed to be out of date by the framework. The Swale Local Plan contains a spatial strategy that presumes against development outside of the settlement boundary. In circumstances where the plan is not delivering the housing required of it by national policy, that restrictive strategy necessarily attracts reduced weight, a matter that has been confirmed in a number of recent decisions in the borough. As such, it's appropriate to consider the sustainability of the location, allowing for some flexibility in relation to where the settlement boundary line is drawn, and in considering national policies. Once this is done in this case, as Mr. Lane explains, the location is a sustainable one for new housing, given that the site is sustainably located and adjacent to a primary focus for new development within the local plan itself. The development therefore promotes rather than subverts the underlying settlement hierarchy. The development does cause the loss of some best and most versatile agricultural land, although the majority of the site does not meet that definition. There is a need in the borough to develop on such land if the borough's housing requirements are to be met. The loss of BMV in context is minimal. This too has been recognised in other appeals, and this loss should attract only limited weight. Accordingly, whilst breaches may be identified in relation to ST35 and DM31 of the local plan, these reflect the out-of-datedness of the plan in that the plan does not provide for sufficient housing in line with national policy. A review should have been undertaken by 2022 but has stalled. Development outside of the settlement boundaries and on BMV is necessary to provide sufficient housing. No significant land use planning harm arises. On the contrary, the appeal proposals represent sustainable development at a sustainable location in line with the settlement hierarchy that's in place. Turning to other matters, a Section 106 agreement has been submitted which addresses the matters raised in the third reason for refusal. In relation to heritage matters, it's common ground that the appeal proposal would not result in any unacceptable harm or impact on heritage grounds. The officer's report conducted an assessment of the proposals in heritage terms and identified some less than substantial harm to identified heritage assets. This is addressed in detail in the heritage statement, which you have, sir, at CD 1.16, and any harm is at the low end of the spectrum. The council concluded that the benefits outweighed any harm, such that planning permission should be granted in accordance with local and national policy. In relation to ecology, the appellant relies on the evidence of Mr. Newell in response to issues raised by third parties, which will be discussed this afternoon. The third parties also raised concerns relating to certain legal issues relating to drainage rights. There's no dispute that there is a relevant easement in place. In general terms, it will not ordinarily be a material consideration of a planning application that the applicant would, if granted permission, need to overcome legal obstacles in order to implement the authorised development. See the British Railways Board case. Drainage will be subject to a negative condition, and this issue does not bear on the public interest balance inherent in the grant of planning permission. This issue was raised before the council, and they were satisfied the appellant and the relevant notices served. So turning to the planning balance, this is an application for housing in circumstances where the council can't demonstrate a 5-year supply of housing land. As such, under paragraph 11 of the framework, the most important policies for determining the application are deemed out of date. This affects the weight that should be given to them, as well as demonstrating that the local plan housing strategy is inconsistent with the framework in not delivering the housing requirements of national policy. This also means that the tilted balance is engaged unless paragraph 11D1 applies. That is, that policies in the framework, as distinct from policies in the development plan, provide a clear reason for refusing the development proposed. And the appellant submits that 11D1 does not apply for 2 reasons. Firstly, because the proposal is consistent with national policy on flood risk, for the reasons I've given, and or, secondly, to the extent that it's not, if you so find, sir, the harm through non-compliance is a matter that weighs in the balance, and it does not by itself provide a clear reason for refusing permission. In relation to that balance, there are many benefits of very real consequence and significance, as set out by Mr. Lane. Firstly, housing. The appeal scheme delivers up to 250 units in an area of shortfall, which attracts significant weight. Affordable housing. The appeal scheme delivers up to 100 units. That's 40% against a policy requirement of 35% of affordable housing in circumstances where the council has declared an affordable housing emergency, which attracts very significant weight. Economic benefits through construction, but also the boost to the local economy generated by the new residents, which attracts moderate to significant weight. Remediation of contaminated land in line with paragraph 124 of the framework, which attracts significant weight. Enhanced flood protection for local residents at the Goldings development, which attracts significant weight. The provision of green infrastructure, public open space and recreational routes, which in combination we say attract moderate weight. The substantial biodiversity net gain should attract moderate weight, and the proposals for delivering an electric car club should attract moderate weight. There's little harm, we say, to set against those benefits on Mr. Lane's analysis. Mr. Carpenter refers to 4 elements of harm. The first 3 are character and appearance, agricultural land, and conflict for the spatial strategy. And for the reasons given above, we say that each of those should attract limited weight. They are the necessary byproducts of delivering the required housing of an out-of-date plan. The 4th element of harm Mr. Carpenter identifies relates to flooding. However, for the reasons given above in summary and to be explored in evidence, that harm seems more theoretical than real, on the basis that no vulnerable development will be placed at risk of flooding. It's submitted for these reasons that the harm does not significantly and demonstrably outweigh the benefits of the development, and the tilted balance is met, so that the presumption in favour of sustainable development applies, and planning permission should be granted. In the context of section 38.6, there are limited breaches of an out-of-date development plan, and the other material considerations plainly indicate that planning permission should be granted. And for the above summary reasons, in due course, sir, we will submit that planning permission should be granted.
Thank you very much, Mr. Williams. Thank you. And I'll now turn to Mr. Clapp for the council's opening. Thank you. So this is ID2. And if I could ask you to send that through electronically, please.
This appeal disposes a clear attempt by developers to avoid the approach to flood risk management, which is mandated by national policy. The proposed scheme also generates adverse landscape character and visual effects, results in the loss of the best and most versatile agricultural land, and proposes development outside the settlement boundary, all of which weigh heavily against the grant of the planning permission. The application was submitted on the 17th of March 2023, and by it, the applicant, Bradman, sought outline permission for a 250 dwelling residential scheme at the land. The matter was considered in detail in an officer's report to the planning committee. The officer recommended refusal, headline for the reasons which are picked up in the reasons for refusal, which I won't read out. Your main issues, which are set out at the 3rd paragraph, which I'm also not going to read out.
Okay.
It's accepted as a matter of record. The council does not have a 5-year supply of housing land. The present supply is 4.21 years. In a nutshell, the council's case of the appeal should be dismissed because the site is located in flood zones 2 and 3, and the proposal is subject to significant risk of flooding, both surface, tidal and surface water, when the effects of climate change are taken into account. And this would impact the developable area of the site absent mitigation. In such circumstances, the sequential test could be applied to determine whether other sites at lower risk of flooding could accommodate the proposed development. The failure to perform the sequential test is totally contrary to the approach to flood risk mandated by the NPPF and is itself a clear reason for refusal of this application, thereby disapplying the utility balance by application of paragraph 11DI, read with footnote 7 of the framework. That's the first point. The second point, the proposed scheme would result in moderate adverse landscape and visual impacts which are significant, as Mr. Edgers will explain this afternoon, and comprise a package of harms which significantly and demonstrably outweigh the benefits of the scheme. The site is not an appropriate location.
Sorry to interrupt. I've been told that. Could you put your microphone on for the live stream? Sorry to interrupt.
Not at all.
Okay, thank you.
Is that working? The
Yes.
site is not an appropriate location for the proposed development. It is not allocated for development and is outside the settlement boundary. There is no local plan support for the development in circumstances given the conflict with landscape and flooding policy, and the proposed scheme would result in the loss of BMV land without appropriate justification in a manner which is in conflict with the development plan, which represents further harmful impact of the proposed development. In any event, the Council will show that the adverse impact of granting permission, namely the failure in respect of flood risk policy, the landscape and visual harm, the locational harm, and the loss of BMV, mean that the adverse impacts of granting permission would significantly and demonstrably outweigh the benefits of the scheme. By application of paragraph 11D2, the tilted balance should therefore also be displayed, if necessary, on that basis. Dealing with main issue 1. The site is within flood zones 2 and 3. It is also at risk of surface water flooding. These risks become exacerbated when one takes into account the effects of climate change, as the Council will explain. The effect, rather obviously, is that the site is at risk of flooding. And notwithstanding that truth, the appellant has resolutely failed to apply the sequential test in advance of this application for planning permission, and now seeks to argue that that key element of national flood risk policy somehow does not apply to this development. The thrust of flood risk national policy is to direct development away from areas at highest risk of flooding. The appellant proposes to build this development on a scheme which clearly is at risk of flooding without having considered any alternative sites which may be at lower risk. The appellant's attempts to justify this approach, essentially, as we understand it, boil down to an assertion that the development of the site will be directed to areas within the site itself which are at lesser risk of flooding, and that's put relatively, and two, that ground raising works can be implemented to mitigate flood risk on those developable areas which remain at risk of flooding. Neither of those approaches, we say, are convincing, and both represent obvious attempts to circumvent the requirements of national policy, presumably because compliance is inconvenient and or expensive. The Council will lead evidence to show that a sequential test was required in the circumstances, and as a result the policy is in conflict with paragraphs 165 to 168 of the framework, the relevant paragraphs of the planning practice guidance, and policy ST 711 of the local plan. The conflict with national policy is a clear reason for the refusal of the proposed development, applying paragraph 11DI and footnote 7 of the framework. That's the first main issue. And the second main issue, the proposed development clearly results in the significant encroachment of housing into the countryside. The proposal comprises up to 250 new dwellings, up to 2.5 stories in height, and alongside associated development and residential paraphernalia. The development will therefore have a strong urbanising effect, given the site is presently an arable field in active agricultural use in the countryside. The development will result in the site effectively becoming a new residential area in the urban area of Faversham. There would be, and as I understand it, broadly agreed, adverse landscape and visual effects which would decline over time, but which would persist for at least 15 years. The Council will lead evidence to demonstrate that the initial moderate adverse landscape effects on the local landscape and in visual terms would be significant. This results in conflict with local plan policies ST1 and ST3, in that the intrinsic character and beauty of the countryside will not be protected, with policies CP4 and 7, as the local landscape will not be conserved and enhanced, and with policy DM24, in that significant adverse landscape impacts remain and are not significantly and demonstrably outweighed by the social and or economic benefits of the scheme. The effect on character and appearance also conflicts with paragraph 180 of the framework, as the intrinsic character and beauty of the countryside will not be protected, and with paragraph 1 through 5 of the framework, insofar as the proposals are not sympathetic to local landscape character. Now, the Council will lead evidence to demonstrate that these conflicts result in a clear breach of the development plan read as a whole. As above, the Council will demonstrate that tilted balance does not apply to this case, given the conflict with flooding policy. But in the alternative, the Council will show that the landscape impacts identified form part of a package of adverse impacts which significantly and demonstrably outweigh the benefits of the scheme. On to main issue 3. This is a proposal for development in the open countryside outside the built-up area boundaries. It is not allocated for development, neither the local plan or the emerging neighbourhood plan. Policy ST3 of the local plan confirms that such development will not be permitted unless supported by the MPPF and where the relevant proposal can demonstrate that it would contribute to protecting and, where appropriate, enhancing the intrinsic value, landscape setting, tranquility and beauty of the countryside, its buildings and the vitality of rural communities. As set out above, Council will lead evidence to demonstrate the proposal is not supported by the MPPF, both in terms of flooding or landscape policy, and that the proposal will not appropriately contribute to or protect the countryside. And it follows that as a straightforward matter of policy, the appeal site is not an appropriate location for development of this type. And finally, just dealing with the BMV issue, it's agreed that the site contains 5.6 hectares of land comprising grade 2 and 3A agricultural quality land. It is also agreed this means that 39% of the site comprises BMV land, as per policy DM31 of the local plan. The proposal fails to meet the relevant test within policy DM31 for when such development may be permitted, and therefore also gives rise to a conflict with policy ST713. The site is not allocated for development, and the appellant appears to accept that there are alternative sites that could accommodate the scheme. It does not suggest that the use of lower grade land would work against the achievement of sustainable development. This results in a further policy conflict at a national level. The proposal does not recognise the wider benefits of BMV and is at odds with footnote 62 of the framework, which requires that areas of poorer quality land should be preferred to those of a higher quality, a provision which is also reflected in the local plan at policy ST111G, which urges proposals to use lower quality agricultural land for significant levels of development where compatible with other criteria. And in conclusion, for the reasons that I've just summarised, and which will become more fully addressed in evidence and articulated in full in closing submissions, the appeal scheme conflicts with the development plan as a whole. Material considerations do not indicate that a decision should be taken otherwise than in accordance with the development plan. The appellant's approach in seeking to circumvent the requirement for a sequential test is directly contrary to the approach mandated by national policy, which is a clear reason for refusal and which disapplies the tilted balance. The proposal also results in a package of adverse impacts, including the unjustified loss of BMV, landscape harm, and conflict with settlement boundary policy, which outweigh the identified benefits of the scheme. In due course, you'll be invited to refuse planning permission and to dismiss this appeal.
Thank you very much.
Thank you
Mr.
very much.
Thank you. Okay, so we're about an hour and a half in, which is normally when I like to take a break. That also was when it was scheduled for. I wanted to check before I did that though. Mr. Atkins, are you happy to come back after a short break, or do you have any time constraints before making your speech?
I've got a medical appointment at 2:30 in Faversham, but other than that I am free.
Oh.
My statement is fairly brief, 1,500 words.
So well, it's really up to you. I mean, I was going to just have a 15-minute break, then we have the openings from the Royal Six Parties, then we hear from you, which it would be comfortably ahead of 2:30 if that's your main concern.
It is my main concern.
Mm-hmm.
I'd rather just get it off.
Okay. In that case, I'm happy to hear from you now, and then that if that's helpful to you, could you come down to someone with a microphone, please? In fact, ask, are you willing to accept questions afterwards or not?
Yes, sir.
Okay, thank you. Please go ahead, sir.
Hello, can you hear me?
I can. Is the speaker on, though? I can't tell.
Yeah,
Okay,
that's
thank
better,
you.
yes. Thank you, sir. I'm a member of the Faversham Society and have drafted this statement as a volunteer on their behalf. I spent my career as a chartered surveyor in the Planning and Development Division and have an honours degree in estate management from the University of Reading. During my career, I worked on the appraisal, acquisition and development of land and led multidisciplinary consultant teams to secure planning consent and then set up and establish development on strategic mixed-use brownfield sites, including waterfront projects. In Kent, these included 2 new communities, each of 2,000 homes, on the former nuclear submarine base at St Mary's Island, set in the River Medway, and at Chatham Maritime, and on the site of the former Empire Paper Mill, fronting the Thames at Ingress Park in Greenhithe. As such, I'm a generalist and not a specialist, and as a consequence, I do not propose to engage with detailed arguments in relation to flood risk assessments. My case is more related to the threats of what I struggle to see as a sustainable location for development. On behalf of the Society, I submitted 7 planning representations objecting to the application on the grounds that the flood risk assessments submitted by the applicant were flawed. They initially overlooked the guidance in the strategic flood assessment, that's the Medway Estuary and Swale strategy, modelled an incorrect defended scenario and lacked clarity as to whether the latest climate change adjustments have been taken into account. I'm disappointed that the Environment Agency are not attending the inquiry. Their initial statutory response was silent in relation to flooding from the sea, and no objection to the application was raised. In response to our representations, the Environment Agency adopted an oscillating, inconsistent and opaque stance as detailed in the Society's appeal statement. They objected to they raised no objection to the initial application on the 20th of June, objected on the 11th of August, withdrew the objection on the 24th of August, objected again on the 8th of April 2024, and then withdrew this objection on the 15th of May 2024. I will leave you, sir, to draw your own conclusions from this. The context of the Faversham Society's objection is the position we maintained throughout the consultation that the science underlying the adopted guidance was more than 10 years out of date. Climate change has accelerated over this period, as evidenced by the multiple intensive extreme weather events we are seeing across the globe. The most recent, closer to home, being the 4 storms that have hit the UK and the intensive flooding seen across Europe this summer. Over 200 died in the Valencia region of Spain last month. The latest United Nations Annual Emissions Gap Report was published at the end of October to brief delegates ahead of COP29. This is an assessment of how much nations must promise to cut off greenhouse gases and deliver in the next round of nationally determined contributions, which are due for submission early next year ahead of COP30. Cuts of 40% are needed by 2030 and 57% by 2035 to get on track for 1.5 degrees by the end of the century to accord with the 2016 Paris Agreement. The GAP report includes an extremely grim statement that current plans and policies will lead to 2.6 to 3.1 degrees Celsius of global warming this century, with zero chance of limiting the temperature increases to the totemic 1.5 degrees C target agreed in Paris in 2015. It's alarming to note that the Copernicus Climate Change Service, which provides forecasts for the European Commission, has just announced that it is effectively certain that 2024 is going to be the warmest year on record, and more than 1.5 degrees above the pre-industrial levels. Despite this call to arms, governments have backpedalled on their commitments. COP29 closed 2 weeks ago. The consensus of the Paris Agreement was fractured by the fossil fuel lobby, and the prospect of a 42% cut by 2030 are, to say the least, remote. The severity and frequency of dangerous heatwave, destructive storms and other disasters rises with every fraction of warming. At 3 degrees C, the climate scientists say that the world could pass several points of no return, which would create tipping points and dramatically alter the planet's climate and increase sea levels. I think you can argue the technical points on flood risk assessments until the cows come home, but there is a severe risk of flooding on this site as a consequence of future increases in temperature and raises in water level. Turning now to focus on the application site, Ham marshes were reclaimed for the sea in the Middle Ages. They flooded in 1953 during the Great Storm, when high spring tides and northerly gales combined to bring a tidal surge along 1,000 miles of the North Sea coast. The Great Storm killed 2,551 people across the east coast of England and the Low Countries. Following the Great Storm, flood defences, including those that can be seen at Ham Marsh, were constructed. Current policy dictates that the Ham Marsh's defences are to be abandoned in 2048. The policy understandably seeks to prioritise the protection of buildings and human life rather than reclaimed agricultural land. In the light of the above comments, the society is compelled to challenge the statement that it is reasonable for the applicants to use the existing strategic flood risk assessment because it is adopted. It is acknowledged that adopted policy status carries weight in planning law. However, it is evident that in this instance, accelerating climate change has rendered the adopted policy as not being fit for purpose. During the consultation period for the applicants, evidence emerged that the key guidance informing flooding from the sea, that is the strategic flood risk assessment, there are several, and I'm referring here to the Medway Estuary and Swale Strategy, and the flood map for planning, issued by the Environment Agency, were being updated. These updates are to be published early next year, and this will take into account the Intergovernmental Panel Climate Art 6 RIP outputs and justifies the Society's concerns. It should also be noted that despite the imminent publication of this new guidance, it inevitably lags behind the science that informs it. Work on IPCC's 7th assessment cycle formally began in July last year and published the outputs in the second half of this decade. UKCP 18 issued an updated fact sheet titled Sea Level Rise and Storm Surge Supplementary Data in March 2023. This includes an extension to the UKCP time mean sea level projection datasets and correction. Sorry, I've repeated myself in my draft here. Updated data to inform flood risk assessments is available now. Paragraph 43 of the planning framework states that right information is crucial to good decision making, particularly where formal assessments are required. Paragraph 43 specifically references flood risk assessments. Paragraph 11 is the presumption in favour of development, and the second exception to that policy is that any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in the framework taken as a whole. The Society considers that there is sufficient evidence to maintain that if development were to proceed as planned, increasing climate change impacts will lead to flooding of the homes. This will have a damaging adverse impact and presents a potentially catastrophic risk to human life and property. For this reason, the appeal should be dismissed. Paragraph 1868 states that the aim of the sequel test is to steer new development to areas with the lower risk of flooding from any source. Development should not be allocated or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. The strategic flood risk assessment will provide the basis for applying this test. Significantly, It also states that the sequential approach should be used in areas known to be at risk now or in the future from any form of flooding. The appellants have not provided a sequential test, and accordingly insufficient information has been provided to determine the application in accordance with the framework. And again, the appeal should be dismissed for this reason. The Faversham Neighbourhood Plan was overwhelmingly approved by Faversham residents at the referendum. That was with a turnout of 17%, which is pretty standard for by-elections and local plans. And the overwhelming majority was 99% of those who voted. On that basis, it should contain overwhelming weight. And that is all I have to say, sir.
Thank you very much. Mr. Williams, do you have any questions?
No, thank you very much, Mr. Atkins. There's a couple of points, sir, there, which I will ask Mr. Whittingham to deal with in relation to the flood risk.
That's fine.
Similarly, I would have questions if I didn't know we were going to be coming on to them later on this week. So thank you very much, but nothing further from me. Anything from you, Mr. Clapp?
No, thanks.
Okay, thank you very much, Mr. Atkins.
Thank you.
Thank you. Okay, I think perhaps we can now then take a short break and we'll come back with the openings from the Royal Six parties then we'll move on to the landscape roundtable session. I think what I might do is have a short break now, then have the openings, and then probably have a slightly early lunch and then come back for the landscape after that. But I'd rather have a short break now just because I feel it just gets a bit too much to go longer than an hour and a half without a bit of respite. Okay, so it's 11:42. If we come back at 11:55, is that okay with everybody? Okay, the inquiry is adjourned. Thank you. Resumed. Thank you. Just to confirm, I have now received Mr. Cook's information. Has that been passed to the other teams as well? Thank you. So we can review that over lunch. Thank you. I have also asked for the Save Ham Farms documentation to be sent round, but I only just did that. So obviously we'll give that a few minutes before that actually arrives in people's inboxes. Thank you. Okay. Next then is the opening from Mr. Cook.
I have to apologise, sir. I don't have a copy of it from my printer. Ran out of ink last night. My wife was riding to the rescue by going and getting some printer ink, much to discuss. So I will be able to print it off this evening and people have copies tomorrow.
Yes, that's okay. Thank you. If I could ask, do you have an electronic copy as well, though, just for the record?
Sorry?
Do you have an electronic copy that you'll be sending round as well?
Yes, I can.
Okay. So if you could do that as well, please, and I'm happy to wait for the hard copy.
I wonder whether it's be helpful to have the electronic copy circulated so we could follow it on screen when it was coming out, or
The difficulty with that will be that
via pins. Yeah.
we'll have to go via pins, and that can sometimes take a while because it goes through the case officer.
Let's do so as long as we have it by the end of the day. that's
Yeah,
fine.
thank you. And obviously, if either side has any questions, then we can
Yes,
deal with it as necessary.
I'm with you.
Sorry, for clarification, it won't be by the end of the day. Oh, the electronic copy.
Yeah, electronic. Yeah.
No, that's fine. No problem. In fact, insofar as I'm concerned, if I've got an electronic copy, I don't actually need a paper copy.
Okay. I'll give you a moment to just digest that note. Okay. Okay. Can I check? Is your microphone on? I can't see a red. Thank you very much. So, Mr. Cook.
Right. Okay, my name is Peter Cook. I'm a town councillor for Priory Ward, in which lies the appealed site. I've been asked by concerned residents from the Save Ham Farm Group and by local residents and local farmers, Andrew and John Bray, to represent them. The Bray brothers ham farm as one of their agricultural holdings. I've also been asked by my colleagues on Faversham Town Council to represent the interests of Faversham. This is the first time Faversham Town Council have actually appeared at a planning appeal inquiry. And we don't have the resources of the appellants to pay for professional representation. Therefore, you're stuck with me, and I apologise for my lack of knowledge of the procedures that I may demonstrate through my inexperience.
If I may slightly interrupt there, just obviously, if at any stage you do want any help or guidance as to what to do procedurally, then please don't hesitate to ask me, and we'll deal with it.
And I have to say that the appellants have already said that to me. So. Having said that, I was a chartered architect and senior partner of a 35-strong professional practice of chartered architects, chartered
Sorry,
civil...
I'm just being... Sorry. Right. Does that include me? Okay. Apparently, due to the way it's coming through the feedback on the live stream, we have to turn off our microphones unless we're actually speaking. So I'll do that now. Keep yours on, Mr. Cook.
Yes. Having said that, I was a chartered architect and senior partner of a 35-strong professional practice of chartered architects, chartered civil and structural consulting engineers and chartered surveyors. At 74 years of age, I'm long retired as an architect, but I remain an active director of a development company specialising in social housing and self-build. Why we are deviating from previous practice is because we've been working for 4 years with interest groups in Faversham to develop the Faversham Neighbourhood Plan. We are told by Urban Vision, our planning consultants, that the Faversham Neighbourhood Plan that was approved at referendum in November is the largest, most complete neighbourhood plan that has yet been produced in the country. The appeal site, we will argue, clearly does not follow the policies of the neighbourhood plan, and therefore, were the appeal to be upheld, it will be hugely damaging to its standing for that plan to be discounted so soon after its ratification, and also therefore hugely damaging to the concept of planning being a plan-led process. The National Planning Policy Framework is clear at paragraph 2 in stating that planning law requires that applications for planning permission be determined in accordance with the development plan. unless material considerations indicate otherwise. And it also states at paragraph 12 that the presumption in favour of sustainable development does not change the statutory status of the development plan as the starting point for decision making. Where a planning application conflicts with an up-to-date development plan, including any neighbourhood plans that form part of the development plan, permission should not normally be granted. Hence, we are defending the Faversham neighbourhood plan by appearing here, and which appearance is an exception to our normal policy. Further, we believe we are defending the integrity of the MPPF and the plan-led approach to planning. We make it clear that Swale Council imposed on us the necessity to find sites for 219 houses in the Faversham neighbourhood area. That is 200 new sites and 19 carried over from the Creek plan. We have exceeded that number. In appearing, we had to consider whether the appealed development should be considered as an exception due to the apparent shortfall in Swale Council's supply of deliverable housing. We also had to look at it in the context of the growth of Faversham through its history and more recently. Faversham is a medieval market town. It grew as a stopping place for pilgrims en route to Canterbury, as the site of a great abbey sadly lost to the pillaging of the Reformation. It was the centre of the medieval fruit industry propagated by Richard Harris for Henry VIII. It was also the centre of medieval gunpowder and munitions making, an industry that continued until the Second World War, when it was relocated to safety in Scotland. In the 19th century, it was the centre of the largest brickfields in the world, and also had two breweries, one dating back to the 17th century. All of this was because of the creek and the fact that it was a safe harbour. The Town Council still has its original Magna Carta, issued to it in 1302 by Edward I, and not to be confused with a slightly different version signed in 1215 by King John, but repudiated by him and the Pope. However, notwithstanding Faversham's past successes, when the Thames Gateway was created in 1994 as a national priority, it included Sittingbourne and Sheppey, but excluded Faversham. Faversham was seen as being East Kent, not North Kent. Therefore, over the last 40 years, Faversham has lost 2,000 more jobs than have been created. This has left Faversham slumbering and suffering as a dormitory town. Faversham being a dormitory town has also created problems, as the A2 in Ospringe has pollution figures that have to be continually monitored, and is so narrow two articulated lorries have passing issues. The Brenley Corner roundabout is at a capacity that creates consistent hold-ups and has long been earmarked for a £20 million improvement that never seems to happen. So east and west car access is bad and causes pollution, and so is highly unsustainable. This, we believe and will argue, is a factor that should bar further large residential development at Faversham that does not also introduce employment. The development the subject of this appeal offers no employment, no schools, no medical facilities, no social provision. We will argue that it should not be allowed. The national imperative to allow only sustainable development argues firmly against it. Notwithstanding this, the success of the Thames Gateway has led to residential growth pressures, and despite not being a part of this area, and therefore not enjoying none of the fruits of success, Faversham has had to support some residential growth that runs contrary to its employment decline. In 2016, we Liberal Democrats only needed to print off 8,000 leaflets to deliver to the town. Now we're printing off over 9,500, all due to the new residential development of the last 7 years. And that will, within the next year, rise to over 10,000 as developments like Love Lane and London Fields are finished off. However, additionally, we have the Duchy of Cornwall application for 2,500 homes, which is currently going through the consideration process, but which we are told is already configured into draft development plan policy. 4 miles west along the A2, we have the Highstead Park development of 8,400 houses that has been called in by the Secretary of State, and which may receive consent before the decision of this Ham Road appeal is known. There is an application for 1,800 houses at Dunkirk, just 4 miles away along the A2 to the east. Given all this other housing that's happened, is happening, and it is likely to happen, the Town Council decided there was no point in considering the Ham Road proposal as an exception to meet a shortfall in the 5-year deliverable supply of housing, not least because even on their most optimistic figures, the appellants have acknowledged that the housing will not be delivered within a 5-year period, that development is not even going to commence within that 5-year period. So, to protect Faversham and its history, culture and limited resources, the Town Council will seek to show that there are too many reasons why the development should not take place, and will therefore argue development should be opposed and appeal dismissed, as the concept of towns being, for dormitory purposes, is old hat and unsustainable development, not a concept to be reinforced by applications such as this appeal proposal. Having mentioned other development applications, I must stress that we believe the overriding factor is the Faversham Neighbourhood Plan, and which is therefore in itself a total and absolute imperative to dismiss this appeal. The Faversham Neighbourhood Plan is and must be paramount. Our arguments against, apart from the Faversham Neighbourhood Plan and existing and proposed development, as previously referred to, are sustainability. Sustainability because the site is isolated from Faversham by way of road network. The so-called best route from Ham Farm to the Abbey School is 3.5 miles by road, 2.5 miles by way of the dangerous Dabbington Hill. There are no buses, no commercial buses that run from Faversham to Orr. The roads and pavements do not encourage pedestrian or cycle access or commute. A shorter pedestrian and cycle route could be created through the green space designated to promote biodiversity, but that introduces lighting, pollution and extensive pedestrian movement into that area, invalidating it as a reasonable habitat site. That links to our ecological arguments. We do not believe the appellants have sufficiently, if at all, taken into account the species-rich green corridor at the rear of Springhead Road and Upper Brents, and we believe their biodiversity approach is qualified. Also, we argued that they have not carried out any ecological or other survey of the Ramsar area into which they wish to discharge their stormwater. That is a matter of fact. They have stated it. Their impact assessment of the discharge relies upon an outlined drainage strategy, and despite the fact that they have misunderstood it. Flooding is a factor for this site. The Town Council considers that not enough consideration has been given to the potential impact on Faversham of displacement flooding that might occur in a 1 in 200 year event as a result of the proposed raising of ground levels to bring development above flood levels. Such displacement could affect existing residential and commercial areas, not least many dozens of listed buildings, including the Grade 2 Old Town Warehouse in Conduit Street. Damage or harm to a listed building that affects its character is a criminal offence, although it remains to be seen whether that would apply here. The Council is also concerned that not enough weight has been given to the frequent flooding of the area into which the appellants propose to discharge their stormwater, and to what extent they will be unable to do so due to that local flooding, which occurs at roughly 1 in 2 years, not in 1 in 200 years, the two being different flood events. So we shall be referring to this. Then there is the question of the legality of discharge of stormwater from the site onto an adjoining freehold. There are several aspects to that. Firstly, the Town Council will argue that no assessment of the Ramsar area has been made. There's been no ecological investigation or assessment. Secondly, there's been no assessment as to the capacity of the receptor area to take the drainage discharge, and no assessment to see what would happen during the frequent floodings of the area. There's been over-reliance in the economic reports on the ability of the ecological reports on the ability of the drainage strategy and its ability to perform, despite the lack of any physical evidence to support such a conclusion. This is not a question of putting newts before humans, but a question of balancing assets and resources based on real knowledge and understanding, and not wishful thinking or mercenary aspiration. Then there is the question of land ownership. The appellants do not own or have any agreements with all owners of the appeal site. They do not have agreement with the Brays. The Brays have requested that I oppose the appeal on their behalf, and they did submit an objection at the application stage. The Brays own land over which there is an easement agreement. We will argue that the easement is not valid. It was drawn up when the dominant tenement was agricultural, and the easement did not refer to the land being developed, nor did it say that surface water from the roads and houses will be permitted to discharge onto the Bray brothers' land. The easement makes no mention of this, and we will argue that there is clear legal precedent to show that the resultant material increase in discharge is not covered by the easement, which does not mention residential development. Further, we will argue that the green line showing the easement route and attached to the easement agreement crosses the land of a third party who have not signed that agreement, thereby invalidating it. Therefore, there is no relevant easement. Landscape mitigation is centred around tree planting. Trees are not a natural predominant feature of the marshes area. We will argue that the lack of control of the we will argue that the lack of control of the appeal site indicates the appellants have no control over deliverability, and that they cannot therefore ensure that the site is deliverable in a 5-year term. We will also argue that the appeal submission has been made not just for residential development, but for a SUDS-compliant residential development, and that there was therefore an onus upon the developer to clearly demonstrate that they could achieve that compliance as part of the application. They did submit an outline drainage strategy, effectively confirming that they needed to prove the case, but it doesn't work and yet must do so for the scheme to be permissible. Implicit in any permission for a SUDS compliant scheme is a decision that discharge into the Ramsar can be carried out. I submit that no such permission should be forthcoming in the light of the failure to carry out the studies and impact assessments required in order to consider the frequent flooding of the area and what we submit as the lack of right to discharge into the adjoining network of ditches. Further, we will make reference to paragraph 188 of the National Planning Policy Framework, which says that the presumption in favour of sustainable development does not apply where the plan or project is likely to have a significant effect on a habitat site, either alone or in combination with other plans or projects, unless an appropriate assessment has concluded that the plan or project will not adversely affect the integrity of the habitat site. There are many applications being considered for development in the area. A level of development Swale East is badly equipped to serve, unless that development includes the provision of employment, educational and medical facilities, among others. Conditions will not help. Faversham Town Centre has limited car parking to serve existing facilities with existing levels of demand. Existing schools have little space to expand, medical centres have little space for expansion. There are no large areas of commercial development sites waiting to be developed. Faversham has had enough. If it is to grow sustainably, it needs jobs and schools and other needs referred to. It needs something other than this proposal. We do not have the resources for the extensive research and exposition of information that we would like, but I will attempt to show through our arguments at this inquiry that this appeal site is not well suited for development as others, and that the appeal site to be developed needs to conform to the Faversham Neighbourhood Plan and does not conform to it and is not therefore an acceptable development. Finally, we will refer to potential impact on the Ramsar and the fact that the appeal site includes land not owned by the appellants, but which is owned by the Bray brothers who are opposed to the development. That affects deliverability of the site, although it doesn't affect the appellants making application for covering that land. We would suggest that immediate deliverability is necessary for the site to be included among the current 5-year supply. Thank you.
Thank you very much, Mr. Cook. Thank you. If I could ask if you could turn off your microphone. Thank you. And finally, then, we hear from Ms. Beaumont with your opening statement, please.
Thank you. Good morning, everybody. My name is Frances Beaumont. I'm chair of the Saveham Farm Group. Saveham Farm is a properly constituted non-political environmental group established in April 2023. We've held 3 public meetings and have over 1,100 signatures on a petition opposing this development. Our large membership communicates through a WhatsApp group, and it's from this group that local qualified naturalists have come forward, generously sharing their time and specialist knowledge. Today, I represent not only the Saveham Farm Group, but thousands of people in Faversham who oppose this development. They have shown by signing our petition and voting yes in the Faversham Neighbourhood Plan with a huge majority that they wish this to be done. I have a lifelong interest in the countryside, wildlife and nature, and I'm seriously concerned about the reduction of species caused by habitat loss and human activity. I've lived in Upper Brents, Faversham, for over 20 years, and Upper Brents forms part of the proposed site's southern boundary, east of Springhead Road. These old houses were built in 1860, and it is now a designated conservation area. My involvement in Faversham matters began in the local residents' association, where I instigated tree and bulb planting in Priory Ward. I was part of the Faversham Future Forum, which initiated Faversham Neighbourhood Plan about 7 years ago. I'm a member of the Kent Wildlife Trust and volunteer tree warden. Saveham Farm wanted to be represented at this inquiry for 4 main reasons. 1 is ecology, 2 is flooding, 3 soil contamination, and 4 lack of transport policy and the creation of car ghettos on this site. Ecology. The proposed site is next to a SSSI and a Ramsar site, but surprisingly the area's wildlife records were poor and outdated. So for 1.5 years, our members have recorded almost daily the wildlife there using a phone camera and the iNaturalist app. This app records the image and gives the GPS coordinates to pinpoint the exact site. The area we were covering mostly was a mosaic of habitats. There is a path, wide in places, through a damp, rewilded field edge. Mature trees and dense scrub and brambles are joining the arable farmland. To date, we have logged over 580 species of birds, moths, butterflies, plants, bats, slowworms and fungi. This site has a rich ecological value that should not be destroyed. In our view, cannot be replaced or mitigated. Flooding. There is an existing problem of flooding by groundwater in the low-lying areas in the back gardens of Upper Brents and Springhead Road. This is mitigated at the moment by a density of trees growing in the shallow valley along the rear of these back gardens. The fact there's no active water is shown that in the past there must have been a spring, because we've got Springhead Road, Brook Road, and the evidence of this valley. We are very concerned about the flooding of the whole site due to climate change, and are very grateful for the contribution just now by Stephen Atkins. But we also have local concerns. One is that raising the proposed site to prevent the new houses from flooding may cause more problems in these low-lying areas. The second is that the houses, the roads and the hard play areas will increase water runoff. The third is that felling trees and clearing the shrubs, as indicated by Gladman all along the southern boundary, will remove the natural defences against local flooding that we have got. And that the floodwater will no longer be clean groundwater, which vegetable patches in back gardens can recover from, but likely to be polluted by the building work and cars and roads. Polluted runoff and increased floods will negatively affect the environment of the current residents. Our third point is about the contamination of the deep aquifer. This area of Ham Farm was formerly used to extract clay to make bricks, and the large depression that was created was backfilled with industrial and domestic waste. Contamination is currently monitored, but there has been no survey of the area we're aware of to map the extent and nature of any contaminants. We are concerned that the clearance, reprofiling and construction work carries serious risk of contamination of the aquifer, which flows in the chalk below the site. This pure water feeds into the freshwater ponds and public drinking fountain at Hearty Ferry on the Ramsar wetland site. This water is the reason that Faversham had so many breweries and is still used by Shepherd Neame. We want reassurance that an environmental impact statement has been made and strict measures will be enforced to prevent contamination of this precious water source. Our fourth point is about cars and the road system. Please see the documents that I have submitted on the 25th of the 11th. I hope they'll be circulated. Due to its position on the northwest fringes of Faversham, away from shops, schools and doctors, and with no bus service, any development on this site will inevitably rely entirely on cars for transport. As I understand it, it is Swale Borough Council's policy to promote sustainable development and reduce car dependency. The Parking Standards Supplementary Planning Document, SPD, emphasises integrating public transport and sustainable transport options in a new housing development. Unfortunately, this has not been the case in the recent development of Faversham Lakes on the other side of Ham Road. It has become a car ghetto with 2 or even 3 car families. The only routes out of Ham Road are a testament to the town's medieval past. The roads are narrow, one-way and full of pinch points, or they are narrow, congested and heavily polluted. It doesn't matter if you go right or left to get onto the M2 motorway. The A2 is a hot spot for pollution all the way along. But it's especially bad at Ospringe, where 2 lorries, as we've heard already, sometimes can't pass each other. I believe Swell Borough Council is sincerely committed to reducing air pollution along the A2, but how will this goal be achieved with hundreds of extra lorry journeys bringing tons of soil onto the site to raise the ground above the expected flood level? Then, if they are built, an additional 250 new households will run at least 500 plus cars, which will inevitably add to the congestion and pollution of the area. I hope to get answers to these questions from both the Borough Council and Gladman during this inquiry. My aim is to prevent this unsustainable and damaging development and protect the green fields and wildlife on Ham Farm, which so many people know and care about. I'm grateful to have Peter Cook's support in this inquiry. From day one, he has given us advice about the intricacies of the planning system. As he and I are speaking on some of the same topics, we'll try not to repeat each other. Thank you.
Thank you very much. Can I ask, will you be sending through an electronic copy of that statement? Okay, thank you. Okay, so I think that concludes matters before lunch, and then we will come back after lunch with the roundtable session on landscape, unless anybody has anything they wish to raise. Okay, well, it's 12:20, so shall we have an hour and resume again at 1:20? Okay, thank you. Firstly, can I check, did you all receive the documents from my case officer from Saveham Farm, the air quality?
We did, thank you.
Areas? Okay.
I have so. But that may be that they've been sent to another member of my team and they haven't come to me yet. You haven't seen them either? No.
Okay. They don't directly relate to landscape, so I'll follow that up.
I'm grateful.
Yeah. Okay.
I suspect it's not an issue that we're going to have very much input in, so it may not disrupt the afternoon. There is one housekeeping matter that I wanted to update you on. This morning I said that the Faversham neighbourhood plan had not been made. That's wrong. It was made on the 4th of December. I'm afraid I just wasn't aware of it. And insofar as it goes, we say Mr. Carpenter has identified conflict with that neighbourhood plan at paragraph 5.48 of his proof in respect of policy FAV 2, which is the very last policy mentioned in the second reason for refusal. And the consequence of that, we say, is that paragraph 14 of the framework is engaged.
Okay, thank you.
Which disapplies the tilted balances, as you know.
Yeah. So the document, in terms of the neighbourhood plan itself, so the referendum version CD 7.18, is that exactly the same as made?
Yes. That's my understanding.
Okay. And in terms of other points, I expect that to be picked up by the planning witnesses as relevant throughout the course of the inquiry. But if you want to say anything now, Mr. Williams, then please do so.
Yes.
Oh, sorry.
Sorry.
I'll come back to you in a moment,
Yes.
Mr. Cook.
That's fine. We're ready to deal with FAV 2 because that's dealt with in the reason for refusal. So as you'll have seen, there's an appendix of Mr. Lane's proof that deals with the neighbourhood plan policies as at the date it was written, which was the referendum version, which we had access to. So the evidence that Mr. Lane has presented is up to date in that regard.
Okay, thank you. Mr. Cook?
Well, just obviously I knew that it was made, and that's why in my opening I referred to the FMP being paramount and part of the development plan process. So I've covered that.
Okay, thank you. And of course, we'll be picking this up with the planning witnesses later on in the inquiry. But thank you. Any other matters to raise before we turn to landscape? Okay, if I could firstly then just understand who is taking part in this roundtable session. So if I just go round from my left, just to understand who will be actively taking part, please. So can you put your speaker on, please?
It's Mr. John Etchells Consulting, on behalf of Swale Borough Council.
And yourself, Mr. Cook?
And myself, sir. Thank you.
So on this side, there's me, who'll probably say very little, hopefully say very little. Mr. Lane, if there's any planning aspects that requires assistance, but primarily, can I introduce Mr. Grimshaw, who's prepared, you'll have seen a summary, a proof, a rebuttal, and signed the statement of common ground on landscape matters.
Okay, thank you. And also just to get an understanding of the documents we should have open in front of us, obviously I've got the relevant proofs and rebuttals and the statement of common ground. I also have the landscape and visual appraisal addendum note, CD 2.16, and the landscape and visual appraisal, CD 1.7. And I'm aware that CDs 9, all of them are in relation to landscape. Is there anything else that you think I'll be turning to?
I think the ones you read out should be fine from ours. Yes, I think so, sir. Thank you.
Okay, thank you. Can I ask behind me, Do we know how it's being heard with the multiple microphones at the moment?
Well, yeah, they think it's okay.
Okay.
Basically, if it's not okay, there's nothing else they can do. So
Okay.
we're just going to have to try and go with it. If we can limit to the people that are speaking only.
Okay, because of the difficulties with the live stream, if I could ask, as far as possible, if you can remember to turn your microphone on and off when you speak, please, just so that people online can hear properly. Thank you, and I'll obviously try to do the same thing. Okay, so landscape. I was thinking about how best to approach this in terms of organising this discussion, and I thought it seems to break down into discussions regarding the existing nature of the landscape and its value and characteristics, and then obviously the assessment, which includes some work on visibility, as well as, of course, the overall assessment of harm or otherwise. And then also, of course, against policies as well. And then a series of comments by yourself, Mr. Cook, in the last page of the Statement of Common Ground, which sort of go towards the assessment side of it. So it seems like a sensible place to start is just to establish where people are coming from in terms of the existing value of the landscape. Unless anybody would like to raise anything else before we start discussing that aspect of this part of the inquiry. Sorry, okay. So yes, if I start then with the council, just to understand your understanding of the existing situation, please.
In terms of landscape value specifically?
Yes.
Yes, well, I think we see some differentiation between the landscape of the site itself, which is clearly farmland, and the wider landscape to the northeast of the Ham Marshes, which carries a local landscape designation. And while I think it's agreed between us and the appellants that the site itself isn't a valued landscape, my view would be that the Ham Marshes beyond the site would be a valued landscape on account of the fact they have a local landscape designation. In terms of the assessment of the level of value, my assessment in my evidence I think accords with Mr. Grimshaw's in that it's of the site and immediately surrounding area, which excludes the Ham Marshes, so it's basically the site and the farmland up to roughly where Ham Farm is to the north. We've assessed that as being of local value. I mean, it clearly has some local value to local people in terms of recreation, the footpaths across it, and you know, we've heard already, and we'll hear again from Mr. Cook, about the value that local people place on it. But because it doesn't have any other characteristics to set it apart from the landscape in general, it is farmland adjacent to the edge of the settlement. My view is that the value is local rather than any higher, but the value of the Ham Marshes beyond the site would be higher, and that would be a valued landscape.
Yes, I noticed you said the word higher in your proof as well. What specific value label would you attribute to the Ham Marshes area?
I think it would be of high value. It is a locally designated landscape. The further out you go, the more nature conservation interests you get, and it is a much more distinctive landscape. There is a real sense of place when you get out there.
Okay, thank you. Mr. Cook, is there anything you'd like to add to that? Obviously, I'm particularly interested in your local perspective.
Yes. Well, firstly, I mean, as far as the NCA 81 is concerned, it says that it is typically grazing marshland with productive arable fields. That is what we have here. The combination of the Ham Marsh and the appeal site is archetypically representative of the description of that area. And there are 13 points in the description of the NCA 81 that the appellant said they recognised 2 of them. Well, I would disagree. I recognised more than 10 of them as being present within this site. So I think we have a strong difference in our approaches there. And I can refer to those if you aren't familiar with them. The area is very important to Faversham Town Council because we are aware we are not a tourist destination, we are a visitor destination. Visitors come down, they come down for a day or a weekend, for a short period, and they're coming to visit a medieval market town, but one which has this incredibly close relationship with the open countryside. The number of people who I was doing a survey in the town centre in the market square last summer, and the number of visitors who said, you know, they look around, they have coffee in the cafes and things like this, but then within 5 minutes of leaving the market square, they can be out within this huge open space. And the open space that you get on that northern side of the creek, it starts the moment that you walk out from the footpath that's between it's at the end of the Upper Brents, and you see this open vista before you. And there is no real physical delineation. There's no solid belt of trees that gives you a delineation between the arable farmland and the marshes area beyond. And also that relates to the area south, because where you've got the Saxon Shoreway continuing round to the south and you've got the Nagdon marshes and walking around there, of course you've got the views out across this area. So that openness is a major aspect, and we are concerned that the development proposal will shut that down. It will be that much of a longer slog before you get out into that open area, and particularly because as part of the development, if they want to have a sustainable short connection, pedestrian connection to the town, it's going to be through that green area that they're proposing at the base, and that will have to be lit. That will be the route that school kids will have to take when they're going to school, because it's too far to come round by the roads and pavements. By road, it's about 3.5 miles round to the Abbey School from the side. So if you like that area, it's going to give it a very different feel to it. It's, you know, with hard paving, it's not going to be the semi-natural area that it is at the moment. So there will be a big difference in the feel of it, and also the layout of the development that you've got at the moment. It's got a road coming round that forms the barrier between the housing and that green space, with the houses fronting onto that. So you will get the road traffic with their lights and the houses with their lights all opening onto that, which again will not mean that has an open country thing. It may feel like an urban park, but it's not going to feel like the open space that it is at the moment. So that will be a major landscape difference. And the other thing is that the existing nature of the marshes and farmland area is actually an absence of trees. They've got hedges, but you haven't got big areas of trees and large trees. And so you start introducing them into this site, you've completely changed the character of it from what it is at the moment. It's changing the character from the characteristic of being part of the Greater Thames Estuary NCA 81. So, to my mind, there will be a very big impact as a result of this development proposal on the landscape.
What's your opinion on how the existing development and very recently being completed development has affected that feeling of moving from the town to the countryside that you've just described?
Well, the Faversham Lakes development, which is on the other side, the northwestern side of Ham Road, doesn't have a huge amount of impact because you go up and you sort of crest at Ham Road, and you've got some hedging there. And so any views of it from the town and from the footpaths are obfuscated by that. It's very different because the proximity of what we will have if this development goes ahead. So it's very different. In fact, I mean, I have been in discussions with Anderson's developers of that to link the country park with the national footpath network in order that we can actually get a system where you can come down through the country park to access it. So that may have some benefits. But to be honest, even with that development, the country park, which is about 45 acres, the country park as it stands doesn't really have, you have to look out towards the marshland to get the openness, because if you look the other way, you get the development, and so it doesn't actually have that much of a country feel to it. And that will be worse as far as the open space at the southern end of this development, because it's smaller and the development will be closer, and you've got the other built development around. So you can certainly get some idea of the impact from actually going to the country park. The development itself doesn't have that much impact when you're walking along the Saxon Shoreway or from Belvedere Road or Stanley Wharf or the other parts of Faversham that look out towards that area.
Okay, thank you. Yes, Mr. Grimshaw, your thoughts on the existing situation, and obviously the NCA 81 point is the area that's highlighted in the Statement of Common Ground as being not common ground. So obviously I'm interested in that as well. Thank you.
Thank you, sir. Excuse me. So in my Appendix 1 to my evidence, I tabulate my interpretation of the NCA and the characteristics of the appeal site. I find there are only two characteristics present, sir, one of which is development pressures, which, because I'm giving evidence to you from the side of the appellant, I have to acknowledge we're discussing development on site. So I don't find that this is strongly consistent with the national character area. Absolutely qualify that, so which is that a national character area is a very large area. It doesn't, that definition reflects the scale at which it's been assessed, not its importance. Every piece of landscape in England is in a national character area. It's not an expression of value, it's a description of character. The particular relevance here is that if one wanted to see an exemplar of that national character area, and a piece of land that had many of those characteristics clearly apparent, I don't think the appeal site is that, and that's what my Appendix 1 states. In terms of my interpretation of the value, so we've agreed it's of local value, and that is because of its proximity to the area of high landscape value, and that it has some relationship to it. And so it's common ground between the council and the appellant that we've used Clivia 3, the Purple Book, sir, and professional guidance. And the LVA method is in the Appendix B, I think it is, to the land. Yes, Appendix B it is indeed, sir, to the landscape and visual appraisal. And probably helpful just to look at paragraph 111 of that Appendix B, so if you have that.
So, just getting it. Okay, I'm there.
Thank you. So 111, so highly valued landscapes typically identified by international designations, such as World Heritage Site, landscapes closely associated with an artist or writer of international renown. So an example in Glivia 3 is Monet's Garden, for example. So just give you an idea of that level of association where that comes in. National designations such as national parks and what would be now national landscapes rather than AONBs. Landscapes of local value may be identified by designations in local planning authority process, such as area of great landscape value, because that is a local plan designation. Although planning authorities may adopt a criteria-based approach to landscape protection and enhancement. So just on the next page, so we have Table 1, which gives landscape values we've used in typical examples. And if we look at local, so a landscape which has scenic quality and rarity, a recreational or tourist offer results in its renown at borough or district level. We've just heard it doesn't offer a tourist officer. And it has some scenic quality, which I've alluded to with its proximity to the and abutting the area of high landscape value. And a landscape with a local plan designation relates to landscape quality, which it doesn't have, sir. So we've allocated it the local value ahead of community value. And I would say, for the reasons I've outlined, which is set out in the method here, sir, that it bumps along the bottom of local, because the area of high landscape value does have that designation. And when the area was assessed and when it's been reviewed, it's not been carried over. It falls a little short, indeed, of the appeal site. And it definitely doesn't bang into the regional value, which is higher there, which is recreational tourist offer, which we've just heard it doesn't have, which results in its renown at a regional or county level. So I think Mr. Cook's honestly described people would not travel from outside the town to look at it. So to my mind, it accurately describes it would not fall into that higher category. So I think the appeal site is elevated from community, because every piece of open land and developed land generally has some value, so that would be community value. So it gets its way into local because of its proximity to that local designation, which it doesn't have, but it's close to it, geographically close to it, but it's some way short of falling square in the middle of that and a long way short of going higher into a regional value. A coarser way of looking at it is where would one go to see similar, and very close to that land you would see very similar land. It's elsewhere, so I've said it's unremarkable, which isn't meant to be rude. It's meant to be a statement. If I was walking across the appeal site or towards the appeal site, I would not stop and remark on it as being particularly distinct or having particularly strong characteristics. That's all that phrase, when I've used that, is meant to convey.
Okay, thank you. Mr. Etchells, do you have any thoughts on that?
Yes, sir. If I could just go back briefly to the national character area point. I think the differences between us might be that we're talking about slightly different things. In that, in the landscape statement of common ground, the matter in dispute says the parties disagree as to the extent the site and surroundings exhibit the characteristics of the NCA. And I think the point is that the site itself may exhibit the characteristics to a lesser degree. And if you look at Mr. Cook's appendix to his proof, where he goes through the 13 characteristics and only finds that 2 of them apply, he keeps referring to the site. The site is formerly quarried land, the site is not subject, the site is not a grazing pasture. Most of which I think is true, the site is not grazing pasture, but the matter in dispute in the statement of common ground was the site and surroundings, and clearly part of the surroundings are grazing pasture and have a feeling of remoteness and are coastal marshes. So, well, as I said, I think that to the extent there is a disagreement, I think it's partly that Mr. Cook in that table is talking about the site, but sorry, Mr. Grimshaw. But our disagreement, myself and Mr. Cook, is that the site and surroundings, I think, do exhibit the characteristics to a much greater degree. And I think I said just now that I would say the landscape value of the Ham Marshes is high. I say in my proof it's higher, but using the terms that are actually set out in my table, which sets out how I determine the value in my appendix, the term would be regional, I think. So I disagree with Mr. Grimshaw. I think that, well, in fact, I'm not sure I do disagree with him, because I think again, he was talking about the site. So I think we've agreed the site and immediate surroundings are of local value, but in my view, the Ham Marshes would be of higher value and would be of regional value for the reasons set out in Table 3 in my methodology appendix.
Yes, that distinction between the site and the surroundings to the site, Mr. Grimshaw.
Yes, it's important, isn't it, sir? Because if we were proposing development in the area of high landscape value, we'd be having a very different discussion, but we're not. So it's important to distinguish between the two, to my mind. So the site does not demonstrate many of those characteristics. Some of the surroundings do demonstrate more of the characteristics. I'm not sure it's particularly helpful to blend the two.
But if you were to look at the Ham Marshes in isolation, what value would you place on that as an existing landscape?
I would apply the method which is set out, sir, so they would be local, because they are a landscape with a local plan designation which relates to landscape quality.
Okay, but you just said high value just now, talking about surrounding areas. Was that?
I don't believe I did, sir.
Okay.
I thought I used the phrase area of high landscape value, which is the designation.
Okay.
Yes.
Okay, thank you.
And how do you think I should be approaching this in terms of looking at the site versus the surroundings?
Well, the way I've approached it, sir, my assessment has been of the site and surrounding area, and I've defined that as being the area within the visual envelope, which is shown on my figure 3. So I think it's wrong only to look at the site. I think you need to look at the area which could potentially be affected. So the landscape value and sensitivity of areas beyond the site are clearly relevant. However, because the Ham Marshes are some distance away, I have defined the area that you need to look at. I've got two shades to the visual envelope on my figure 3, and the darker purple dotted line is what I've called the main visual envelope, within which I think the main effects of the development would lie. But because you can see, you can see the site and you would be able to see the development from further out, all the way out to the Saxon Shore Way, I've included that in a paler coloured dotted line and said in the key that there's limited visibility only from this area. So I think the main effects would be within the site and surrounding area up to roughly Ham Farm and out to the creek, but there would be some visibility and some effects from beyond that. So while the main effects wouldn't be on the Ham Marshes, I think there would still be some effects. I think we've both identified visual effects for people walking along the Saxon Shore Way. So clearly, if you can see the site and you could be affected visually, there would be some degree at least of landscape effects, and that would be within an area of higher value, albeit because of the distance involved, the effects would be less pronounced because it's simply further away.
Okay. Could you direct me to figure 3, please?
Sorry, it's figure 3 in Appendix A of my appendices, which are a separate volume from my proof.
Okay, I'm looking at it now. Okay, thank you. Yes, Mr. Grimshaw.
Yes, it's important not to conflate landscape and view, sir. guidance is very clear that they're related but separate. So we've gone from a description of landscape and landscape character into a description of visibility, and they're not the same things. They're related but not the same things, sir. When one looks at the characteristics of the area of high landscape value, they don't include things which are on the appeal site, such as stoned arable fields. They include, as been described, grazing pasture, which is not present on the appeal site. So I think there is a distinction between them, sir, which is what I'm maintaining, and I thought had been agreed.
Okay, thank you, Mr. Cook.
Well, landscape is visual. I mean, landscape is the features that you can see. That's the definition of landscape. Landscape is not a single patch of land. It's the vista, all the things that that are within your eyesight. And so standing at any point on any of the public footpaths or opposite the site, you can see beyond the site, around the site. What you can't particularly see is beyond Ham Road, but then that's also partly because, although reference has been made to the Faversham Lakes development, it doesn't overlap with the appeal site by very much. The majority of the northern elevation of the appeal site is open to the lakes and country park, not to the development. You actually have to be looking across at an angle to see the development. So very much this field, this area has to be seen within the wider area as a landscape, and I think that it's really not reasonable to try and suggest that the field is landscape in itself, because it's like referring to your garden as a landscape. I mean, yeah, maybe if you've got a country house somewhere, but not for the majority of people. So I don't think it's appropriate.
Okay, any final comments on existing situation? Yes, Mr. Grimshaw.
Yes, I just need to make the observation on there. There's a bit of having it each way, really, which I may be accused of, sir. So I'm hoping to help out a little. If that is the case and it's all visual, then one can clearly see Mr. Etchell's dotted line includes the housing around the appeal site, including the new housing as well. So that is part of the landscape, sir, the existing situation with built form. Thank you.
No, just to say briefly, sir, yes, I agree. The fact that you can see existing houses in the Harvey Drive development and to some extent the Faversham Lakes development, and to a lesser extent, I think, Springhead Road, because those houses are reasonably well screened, is clearly relevant. It's part of the existing landscape character, just as it is also part of the character that if you go in the other direction, you get the more expansive landscape of the marshes. So whatever you can see or whatever surrounds the site is relevant, I think, in terms of landscape character.
If I may just say on that, yes, I agree. The houses in Springhead Road are largely screened because you do have a wildlife corridor running down that side of the site, which is flagged up on figure 7 of the neighbourhood plan as being of some significance. However, if you look at the ecological plans and the site layout, that is to go. It says in the landscape strategy that it's going to remain, but in fact on all the other plans it's shown as going. So Springhead Road, etc., wouldn't be screened if that were the case. And I think, as I recall, the point was made as it will go because it gets in the way of the development. Well, the whole point, development in this area, it's supposed to be, and I think it says within Mr. Grimshaw's document, that it should be landscape-led. If you're saying, well, we want to get away with this species-rich area that screens the existing rather ugly development of Springhead Road, just to facilitate development, that's not being landscape-led.
Yes, Mr. Grimshaw.
Thank you, sir. On species, sir, and biodiversity, I'll defer to Mr. Newell, who'll be coming on there. The proposed landscape treatment to the open side of the development will replicate that which is presently there for Springhead Road. So to the extent that we've heard that landscape treatment at Springhead Road is appropriate and successful in that it screens those dwellings, that has arisen through natural succession, I would say, sir, rather than a landscape which has been installed from nursery grown stock and which has been subject to a maintenance period which, to tread on Mr. Newell's toes a little, will extend to 30 years for BNG. So the growth rates will be greater. The species will be picked to be appropriate and fast growing. So we're talking about a successful existing landscape treatment which will be replicated quickly on the boundary of the proposed development.
If I refer to 714 of Mr. Grimshaw's statement, it says the most distinctive part of the appeal site is the vegetation to part of the western boundary, contrasting with the otherwise largely open field. This vegetation would be retained.
Certainly, sir. In the development framework plan, sir, shows the taller vegetation retained, but that is indicative, sir. When you opened this morning, you referred to the two plans which form the application, which are the location plan and the access plan, as I recall. Everything else is matters to be controlled at reserve matter stage and by condition, so that would be subject to further submissions. But the clear intention in illustrative material is that the taller vegetation adjacent Springhead Road would be retained.
It certainly wasn't my understanding, so looking at the drawings, yes. Because I think that band of vegetation is about 25 metres wide. So if Mr. Grimshaw is now saying that that band of vegetation would be retained in its entirety, then that's very interesting.
Very different.
So I didn't say that. I said the taller vegetation.
Sorry, just repeat yourself, sorry.
Sorry, sir, I didn't say the entirety of the vegetation would be retained. I said the taller vegetation, sir.
With greatest respect, you say this vegetation would be retained.
I'm happy to have clarified for you. I think I have.
Okay, thank you.
Sorry, just to say finally, so I think in practical terms, then, it would presumably have to be only a thin line of vegetation where the taller vegetation happens to be more or less along the site boundary, because the intention is to build houses there, so there would be people's back gardens. But as Mr. Grimshaw says, that will, more detailed proposals will come forward at some stage. But as I understand it, the intention is that most of that vegetation will go, and it will no longer be what it is at the moment, which, as Mr. Cook says, is a broad band of vegetation which, it's not my evidence, I don't know, but Mr. Cook says it has nature conservation value.
I didn't realise this was a disputed point. I thought the situation of what's proposed is what it is within the parameters of it being an outline application. And it's just for me to consider that as a decision maker, I think, in terms of what impact I think that has.
I think when you visit the site, you'll see the nature and width of that area, that wildlife corridor. It is extensive, and that isn't reflected on the development plan proposals that have been submitted by the appellants. So it will be fairly obvious that it's not being retained.
Okay, thank you. Yes, Mr. Grimshaw.
So if I could just to reiterate, Mr. Newell will address the biodiversity matters when you visit the site, sir, hopefully in more clement weather than yesterday. You'll be able to see the extent of the vegetation and the nature of it and the heights of it. My point, which I'll restate, is that we've heard it is very effective at screening existing built form, and that's the reason why similar has been proposed for the new settlement boundary to replicate that, and the means of achieving that are very readily demonstrated and very able to be controlled by condition, not least because, as I stated, it will be nursery stock and it will be managed during its establishment and for a long period afterwards.
Okay, I don't think I need to hear anything further on that. I understand where both sides are coming from. Okay, thank you. And we have moved on to sort of the assessment side of our discussion. I think I'll start by asking the council and Mr. Cook just for their key concerns, but just to bear in your mind things that I'm thinking about. There's obviously been the evidence submitted regarding visibility, and I'm also interested in the position at 15 years, so the mature landscaping position. But of course, just highlight your case as you see fit with regard to what's proposed.
Yes, so if we're sticking with landscape effects, I think myself and Mr. Grimshaw have come to broadly similar conclusions in that the effects on the local landscape, which my definition is within the main visual envelope shown by the darker dotted purple line on my figure 3, would be moderate adverse initially. And I agree with Mr. Grimshaw that there would be some mitigation of the effects over time as a result of the new planting principally along the northeastern boundary, and I think we agree that the effects after 15 years would reduce to minor adverse. But I think what I would point out about that is, in my view, those minor adverse effects still need to be borne in mind and taken into account in the overall balance, because they're minor adverse effects, so they have been mitigated from the initial effects, but they affect a large area of land extending out some distance from the existing edge of the settlement, and within the site itself there would be a greater degree of harm and greater effects inevitably, because the site itself would change from being an area of open farmland to being a new residential estate. So the minor adverse effects would be really on the landscape outside the site. Beyond it you would get higher level effects within the site, but I think we're agreed that the effects would be mitigated by the proposals, and the effects on the area around the site would reduce to minor adverse by year 15.
Okay, thank you. Mr. Cook, anything you'd like to add?
Yes. Well, obviously one can put in some screening using trees as mitigation element. But as I said before, I mean, trees themselves are an alien feature in this landscape. So yes, they would be mitigation in terms of obfuscating views of the development, but that's hiding something which is bad by something which is less bad. Neither of them are particularly desirable in this context. And also it should be remembered that the proposal is to raise the levels of the land, which will alter the landscape. And that obviously will, notwithstanding the existing screening to Springhead Road, without wishing to labour the point, but once you start lifting the houses up, and you talk about 3-storey houses, it's very difficult to screen the Springhead Road properties from them, or them from the Springhead Road properties. So the overall impact and the other aspects which concern them, the idea that they want to front the green area with houses, having houses fronting onto it, makes that green area a part of the development. It makes it more of an urban feature rather than a part of the countryside. So you're not walking through the countryside to get to the marshes area. As a result of that, you're just walking through an urban green area, which isn't, it's better than not having it, but it's not a highly desirable objective. So I think that's is important, and so I think too it's wrong to do too many comparisons, or indeed really almost any comparisons, with Faversham Lakes, because Faversham Lakes was the development of a brownfield site, whereas this is a greenfield site. and that's why, and Faversham Lakes area got zoned in the local plan because of that, and has given many environmental benefits as a result of that area being developed. That was the former Marsh gunpowder works, which had 2 explosions in the mid 19th century, killing, I think it was a total of 67 people. And indeed, some of the highly explosive gun cotton is supposed to be buried on the marshes, and if it's ever dug up and dries out, it will still be explosive. But I doubt that it's underneath the development site, so we don't have to worry about that. But it's certainly the visual aspects in terms of looking at development can be improved. I don't think the existing layout is at all a sensitive layout, not a sensitive development of that site, both because of the impact on the green area to the south, and therefore also beyond that to Belvedere Road and Standard Key, etc. And the impact it would have on that, and it's not going to have a very good impact on the Springhead Road. And although they talk about leaving the open area around to preserve the setting of the listed buildings of Ham Farm, well, the actual area that's being left is zoned as the swell recovery network area, which we're looking to try and bring back in quality. So that's really why it's been left.
Okay, thank you. Yes, Mr. Grimshaw.
Thank you, sir. It's common ground between us, as Mr. Etchells has acknowledged, that there would be a change to the field on which development will take place. Of course there will be. There will be houses there. That's completely accepted. It's common ground between us that year 1 on completion, when the first planting has been put in and hasn't even come into leaf yet, there will be moderate adverse effect. It's common ground between us that by year 15, that will have diminished to minor adverse effects. With regard to the effect of the new development in the locale, sir, I think it's best left for your judgment at the site visit. We can discuss differences between us, but I think you can go to site and appreciate what effect you perceive from that existing development. Thank you.
Etchells, sorry, I'll come to you in a moment, Mr. Cook. Mr. Etchells, yes, given that there is common ground that there's a minor adverse impact of 15 years, what, in your opinion, is the key differences between the parties here?
I'm not sure in terms of the actual levels of effects that there are any. We have both carried out a sort of technical assessment of landscape effects, and we've come to broadly similar conclusions. I think there may be some difference of interpretation as to what you should then do with that conclusion, sir. And my view would be that certainly the short-term effects are significant and need to be taken into account and weighed against relevant planning policy. But my view would also be that you shouldn't discount the longer-term effects, because even though they have been mitigated and they have gone down to a lower level, as I think I said just now, in my view, you should take into account in your overall balancing of the different factors the fact that there would still be long-term residual adverse effects, not only in terms of the actual loss of the farmland where the new houses will be built on, but in terms of the effects on the wider landscape, which would be at a lower level. They would have been mitigated by them, but it would still be harm. So I think that, and Mr. Grimshaw may say something different, but in my view, even the minor adverse effects are still long-term harm, and they do need to be taken into account.
Thank you. Mr. Cook?
Oh, just a factual point, really. Mr. Grimshaw's statement says, the landscape statement of common ground notes paragraph 2.3 that the site levels vary between 4.5 metres to approximately 7 metres AOD. They actually vary from 3.16 to 7 metres AOD, according to the survey submitted by the appellants.
Could you clarify that, please, if you can?
I don't think there's anything very substantive in that difference, sir. I say approximately 7. I think you've said 7.7. So that's quite a way more than 7, but approximately 7 is not very difficult. And then I think, was it 300 mil at the other side?
No. It's 1.4 metres difference. In fact, the areas goes down below 3 metres, but I've said 3.16.
How does this practically affect the assessment?
It doesn't, from my point of view, sir, it doesn't materially change those. And I think that's very amply demonstrated by the zone of theoretical visibilities, which I've submitted in the supplementary proof, because I'm aware there was some comment and observation about those and heights of buildings. So I don't think those differences that have just been pointed out, which are not my specialism, and I gave approximate levels, I don't think they're material, sir, because there would be a need to work the site and secure levels. So I think it's all in the ballpark of what's been considered.
Is there any way to confirm either way what the correct figures should be by reference to a core document?
I could pull up on here a copy of the survey and
Is that a CD number?
just, if I go onto the swale. Sorry, it's a little slow generating. I don't know if the appellants have any of their topographical surveys to hand.
Yes, Mr. Lane?
So if my Appendix 8, which provides the LDA condition, has the site plan with levels on it.
Okay, so that's Appendix 8 to Mr. Lane's proof.
They were attached to the drainage strategy, which is where I got them from.
I'm just loading it up now. It's the last page of your document. Do you have that in front of you, Mr. Cook?
Sorry?
Do you have that in front of you?
I do now, yes. And if you look at the strip of land to the far north, the levels there are shown as 2.43, and they're gradually coming up through the 3s, low 4s, getting up into the mid 4s. You hit 5 metres as you come into the wider part of the site.
Yep.
And then you have an area in the middle which is around, at its highest 7.66 there, 7.72. I think you've got a high spot of 7.72, and then you start dropping away down into the 6s, and then down into the 5s, and then down into the 4s.
So is this where you took your information from that you've just described?
Yep. I mean, either they're only going to raise up the levels of part of the site and leave parts of it lower, which we haven't seen. I haven't seen a statement to that effect, or they're raising the heights overall. I don't know. All I'm saying is that if you're going to say that the site is a level of 4.6 to 7, it's not strictly accurate. When it actually goes down to, well, in fact, to less than 3, but I was being generous in saying 3.4.
Okay. Yes. Anything further, Mr. Grimshaw, on this point?
No, sir. It was approximations that I used to. I've put it in the general site description, and I noted in the LVA. I think the LVA says the site is generally flat, and I just looked for some more information. I may have taken it from Ordnance Survey extrapolations, but and I don't think there's a great difference there between what I said and those survey figures, which I absolutely cannot quibble with. I think the lowest point, sir, from the look I've just had, is at the low point by the discharge. So I would have been far more concerned where built form would have been, and probably focused my attention there.
Okay. Thank you. Are there any final points that either side wish to make? I'm also thinking about site visits. Obviously, that's a key part of this kind of discussion. So if I could ask that the parties in the background work out where they want me to go, what they want me to look at as part of my formal site visit, and then present that at some point this week.
Yes, sir. I've spoken to Mr. Grimshaw about it, and we have agreed that between us we'll agree a route, and we can also run that past Mr. Cook. So if you've got anything specific, but in general, I think it will just be some kind of circular route around the footpaths near the site. And I think you may also have to go along the Saxon Shore Way as well, so you might need some wellies, I think. But yeah, we'll agree a route between us which takes you, without going too far, to all of the viewpoints that between us we think you need to look at.
Okay, thank you. Okay, thank you very much to everybody. Sorry. Next will be Ecology, but we'll have a short break first before coming back for that. So it's 2:17. So if we come back at 2:35, is that okay with everybody?
Yes, of course.
Okay. Okay, so the inquiry is adjourned. Thank you. Assumed. Okay, so next on the agenda is Ecology, roundtable session. So as before, if I could have anyone who wants to take part in this, please sit in this first row, please. Okay, I think we've heard from everybody except for Mr. Newell. So if you could just introduce yourself, please.
Yes, thank you. My name's Mr. Andrew Newell, and I'm an Associate Director of Ecology with the Environment Partnership.
Okay, thank you. So as before, it'll be a discussion led by myself. Thinking about the ecology issues, the sort of headlines that I took from the evidence were sort of disputes regarding the value of the ecology on the appeal site itself, issues to do with potential impacts on the marshes and the Ramsar from off-site impacts, and then potentially, depending on how you define or badge this, the sort of land ownership easement issues as well, and just impacts on ecology. Are there any other sort of headline areas that you think we need to cover, or is that covering everything that everyone wants to discuss this afternoon?
I don't know if this is going to include the aquifer under the site as in the wider area of ecology.
We'll certainly make sure we cover that.
And I guess biodiversity net gain specifically can be covered. We haven't looked at any details in terms of the aquifer. I mean, that, as far as I'm concerned, would be more of a kind of a drainage and aquatics issue rather than a specific ecology issue.
Okay, I think there will be overlaps here between drainage and ecology, and I think we just have to work our way through it as best we can because we know we're coming back to other points during the inquiry. Okay, thank you. Perhaps I can turn to you first, Ms. Beaumont, about the ecology on the site itself and what you think makes it valuable.
Yes, thank you. Yes, I do feel it is a very valuable site, and the reason is that we've spent a lot of time, about a year and a half now, on almost daily monitoring of the site, which is pretty unusual to have this depth of information. And the information has been collected on the iNaturalist app by local naturalists. We have quite a few in the area who've come and helped us. And the iNaturalist app is a very accurate record because you take a photograph on your phone and at the same time it gives a GPS. So you know exactly where it was taken, and we've limited all these findings to the site itself, not even to the surrounding areas. So we could have gone further out, but we've actually asked them just to stay within the designated site. So through this method, we've discovered, to our surprise in a way, There's a great deal of life in this area, especially bordering the field where there's this rewilding has gone on. Now, as I'm sure you know if you have walked it, the width is about 20 metres or maybe less, maybe more in some places. And it has a path running through the middle of it, very old path. And it's naturally rewilded itself. And it's we found over 20 species of tree there, quite naturally growing, including walnut, oak, ash, and I've got a list here if you want to know more. But it's quite surprising what nature will do on its own. That's a really rich site for trees, plants, fungi, and we've been very surprised by the amount of moths that we found. 178 varieties of moths. I mean, really quite extraordinary. And they're such beautiful creatures as well. They've opened our eyes to the rich life that is going on there. So we've come to regard it with great respect that this area has such a rich wildlife, and we feel it does need protection. This area is important because it's a buffer between the housing and the farmland and the wider landscape of the marshes, and it's marked on the Faversham Neighbourhood Plan as a green line, which is a green corridor. This has been an important part of the plan right from the beginning, and it makes a visual shield for the houses in Upper Brents and in Springhead Road. So it's actually bordering the back of all their fences. And because the path is running through this area, in fact, it may be the reason that this area is there, that this very old path is running directly from the creek originally to Ham Road, a straight path. I hope you've seen this on the maps I've sent in. It's very clear this is a very old and established path. And so it's grown on either side of the path as well, and the path has been preserved because it's such a useful facet of the aspect of the place. So yes, we feel this isn't just a bit of old scrub land. It's not poor quality land as been described by TEP, and that it deserves some protection. The whole area deserves protection because it is a green corridor, and it links up the small amount of green in the area and coming all the way along that edge. Now, the Priory Ward is rather a poor area of Faversham, actually, a lot of it. Brent's estate is an old council estate, and the Priory Ward, compared with other wards in Faversham, is extremely low on tree cover. It has only 8% tree cover, where 20% is recommended, and other wards in Faversham are also a bit low, but not as bad as Priory Ward. And I've been involved in the past when I could dig with planting trees on some of the sites in Faversham. So to actually denude it of this group of trees, this whole length of trees and this variety of trees, is an insult to the poor old Priory Ward, which is already suffering a lack of trees. This is why I feel it's an important site, and it should be recognised as such, and not just be given a low priority as been done by TEP.
Okay, thank you very much. Mr. Newell, just an understanding of your perspective, please.
Yes, thank you. So it is noted that the site has been monitored by local individuals over the last year and a half or so, and they've been using the iNaturalist app to record those species. We're absolutely not refuting any of those species records, and it's good work. What I would say, and this is what I've said in the comments, records don't provide any context. They are just species records within a site. And TEP has undertaken a suite of ecology surveys. Now, I would admit that the surveys that we undertake are very much focused on protected and notable species, because those are the material considerations in terms of a planning application. But the surveys that we undertook, they weren't intended to be an audit of every species within the site. The surveys undertaken are considered proportional to provide a robust baseline for assessment. And I think it's important to note that the surveys completed are undertaken with regards to standard methodologies, and that is important because it means that the baseline produced is robust and is easy to interpret by the competent authority. At the application stage, that was clearly Swale Borough Council, who did not list ecology and biodiversity as a reason for refusal. But obviously, you will be the competent authority in the context of this inquiry.
Okay, thank you. Would you like to say anything further?
Yes, I think we've recorded, as you know, 14 red list species there and 27 amber list species of birds alone. So that is really a rich site. Some of them are overwintering, and of course, the TEP ecologists could only visit briefly. They were, I don't think, visiting much in the winter to see the wintering areas. Some of the days they came, they were spending on the Swale, on the Ramsar site, so they were counting an awful lot of geese and other birds, water birds, which are actually 22 kilometres away, not really what was on the site. So that's where I think we have quite a strength in this, because these were all exactly on that site. And though it's true, we weren't monitoring what the birds were doing at the time we were photographing them. The fact that they were present, and including the very rare Setti's warbler, which seemed to be there at a nesting time, which is an extremely rare bird. So that's why it is a special site. I agree with you that we probably didn't follow all of the protocols that the ecologists did, but there we go, we're amateurs, and though the naturalists who we were using are all very experienced and in the local area with many qualifications as well. So one of them has been the main bird gentleman, Richard Drew, has been bird spotting for over 30 years, and he was out there nearly every day, one time in morning, evening or night, and has an extremely good idea of what was there. So I don't know if that answers that point for you.
I mean, I... I mean, in terms of the red list species, I think I noted that the red list species that were detailed by Mr. Cook in his evidence, we had recorded all of those species, all but one, in terms of the ornithological surveys that were completed, which was Wimbrel, I believe. The winter bird surveys that were completed, which were provided as an appendix to the ECIA document, which is CD 2.4, and were also used to inform the Shadow Habitats Regulations assessment, were completed. So the ECIA is CD 2.4.
Yeah.
And have you got that in?
It's loading. Yeah, it's got it now.
And the winter bird surveys followed a robust survey methodology. There were 2 survey visits per month over the winter period, which included the spring and autumn passage periods. You know, the winter bird survey specifically looked at target species for the SPA, because, you know, as well as looking at the general assemblage, the surveys were very much geared towards looking at whether or not the site was functionally linked land for the SPA. And so target species included mainly waders, wildfowl and raptors, waterbird species, but also red and amber list species, Section 41 priority species. And yet the surveys did take in the site themselves during every survey visit, but there was also a transect walked to look at the 500-metre buffer, which took in the Faversham Creek and areas of the Ham Marshes that lie within the SPA and Ramsar site. Those being buffer habitats are of higher ecological value because they're within the designations.
Mm.
Okay, thank you. Yes, Mr. Cook.
Sorry, if I can just make a couple of comments. Beaumont's already referred to the species found in that wildlife corridor, which exists at the back of Springhead Road. I mean, historically, as the plans show, there's been a footpath there for over 150 years. Because of that, it wasn't excavated with brick earth. It hasn't been used as a housing. It hasn't been ploughed up by the farmer, and that's enabled the vegetation to grow up around it, and has created this habitat. Over 150 moths found. The fact that there's such a huge variety of species, such a huge variety of moths, is one of the reasons why also that the bat group that was brought in to look at the bats just registered a lot of bats, 3 types within that area. It's an important corridor, and I'd like to refer to the fact that that is on Fig 7 of the Faversham Neighbourhood Plan as a wildlife corridor, as something to be protected. And at the moment there aren't any proposals within the development plan to protect that area. The sparse trees lining the boundary will not replace the width of that existing wildlife corridor. It's referred to as bramble scrub, but that doesn't really do it any service. Even slow worms have been found there, and they don't like the very dense stuff. So it's been quite rich. The other aspects that I wanted to refer to is that obviously they're looking at the green area still being there as an area which birds can visit and give biodiversity gain. But if there's going to be lighting through there, which there will almost inevitably have to be to get the connectivity with Faversham, rather than just a connectivity during daylight hours, then a connectivity that will enable kids to walk back from after school activities and still get home, etc. That lighting pollution will negatively impact on wildlife. It's been well established that lighting interferes with nesting, it interferes with migration, navigation, it interferes with feeding habitats, and so there will be clear negative impact, obviously from the lighting generally within the development if it's allowed, but specifically within an area that's being allocated and flagged up as being a contribution towards biodiversity gain, and I think that's a very dangerous thing. So that needs to be looked at, and I do think that the presumption that that wildlife corridor should go because it's in the way of the development, which is stated in within the TP report, basically is false, because the whole point of this is it's to be landscape led. And that's not being landscape led. It's not being habitat led. It's actually just bulldozing flat what they don't want and then saying, well, we'll create a new one. Well, the trouble is that if you may create a new one, but you're also causing the cessation of an existing one, and that creates a gap. It takes a long time before that anything new will ever get close to what's grown up over hundreds of years. So I think that it's wrong the way that has been discounted, because there is no requirement to do a condition survey on bramble scrub. But that doesn't mean that bramble scrub doesn't have a rich panoply of wildlife, and as has been seen from the study done by the Safe Ham Farm Group.
Okay, Mr. Lane.
Sorry, sir. Yeah, if you could just turn up my proof and page 5 and figure 2.2. That shows the appeal site within when it was within the phase of being a gravel working. And it was just a point of clarification that as recently as 2009, and actually if you go through the Google aerial photography, much more recently than that, there was nothing there at all. And I think that goes back to Mr. Grimshaw's point that it's all principally self-seeded. It's of course, Mr. Cook. Yeah, it's my proof on page 5. It's the aerial photograph from Google Earth.
So keep your microphone on, please.
Certainly at the moment there are over 20 different varieties of trees, some really mature trees there. So it's grown up really quickly, and that's all I can say, and it will do so again, I'm sure, if we get another site. But it's the width of it that's good, not just a single line of trees, you know, that cannot support that biodiversity of moths and so on. And so I'm not quite sure what your point is over that.
That's okay. No, I need to understand the position of both sides, so thank you. Is there anything else on the ecology of the site itself? Yes, Mr. Newell.
Well, I mean, I was going to come back on that point that, you know, ecology is always quite an emotive subject. But I think when you take a step back and have a look at the site, it's largely a big arable field. There is that strip of vegetation. When you look at the actual composition of that habitat, it is largely bramble scrub with some areas of grassland around it. They are habitats in and of themselves of low intrinsic value, but that's not to say that they don't have value for species, and the ECIA report produced has identified that those habitats are used by a number of species. So bats, you know, there was mention there that 3 species were recorded. We actually recorded an assemblage of 7 species within the site, not just slow worms within the site, but common lizard and grass snake. Okay. A lot of survey work has been undertaken, and the value of the site has been recognised. But mitigation can be put in place to replace that habitat. The habitat itself, as I mentioned, is bramble scrub, is not a difficult habitat to replicate and to mitigate for. And the species present there, mitigation can be put in place to prevent harm to those species. So, for example, a reptile mitigation strategy was submitted to Swale Borough Council as part of the additional information that they requested, and they confirmed that sufficient information had been provided. And again, they didn't raise ecology and biodiversity as a reason for refusal.
Yes.
Can I just say that it's also in the context of the area that you're in, because we've already suffered some losses. The Faversham Lake site, which was a brownfield site, was for quite a long time neglected, quiet, and became a wonderful bird reserve by itself in a similar way, rewilding itself. And it was famous for its nightingales, but of course now all the houses are on there, they've gone, and the replacement of some green fields with a park for dog walking is really a very poor substitute for the rich bird life that was there, which is only just across the road. So Faversham Lakes has suffered an ecological loss. Now if this is another loss, it's just compounding what's happening locally. As I'm saying, the tree cover is so poor in that ward that I think it's going to be especially difficult to justify taking all those trees out. And you might leave a few along the boundary edge, fair enough, all the big ones, but it's the density and of those trees, which I'm sure you've seen, and the brambles across are easily to replace, but they're part of that as well, and that's why birds like Setti's warblers have the privacy and the safety to nest there. So I don't know that it is going to be that easy to replicate. The little string of trees that's going to be planted along the brow of the hill, I can't see that's any way going to replicate this. You also said about the replacement where the reptiles are going to be moved, the slow worms are going to be moved on, as I understand it, onto the one clump of trees in the middle of the field, which is called Goat Pen, which is going to be part of the play park in the future, and also along a strip of land, as they say, from the trees along to Ham Road. Now there's a strip of trees which haven't yet been planted. It all has to happen before the building, so there won't be planted trees there. So if the slow worms are placed on that site, which is going to become a play park for children and dogs, I can't see the survival of slow worms in that environment, and I'm really surprised that the council agreed to that as a suitable place to move the reptiles to.
So we just very happy to deal with this. we are moving on, it seems to me, from existing site value to mitigating the impacts and effects. Now, I just wonder if it would be helpful if Mr. Newell explained some of what the proposals were in that regard, so that that's out there for description, and then, of course, we can answer questions on the effectiveness of those and what further steps have to be gone through by way of reserve matters and conditional discharge of conditions.
Okay, yes, please.
Yeah, so in relation to reptiles, the reptile receptor site that's been identified is not that clump of trees. It's actually a strip of habitat that will be created grassland, hedgerow, scrubs, scrapes along the northern site boundary. As a receptor site, that would need to be created in advance of any impact. So it's in a state that's ready to receive and carry the population of reptiles that's moved into that. As I said, the mitigation strategy was provided to Swale Borough Council, and they confirmed that they were happy with the details that were provided.
So I think CD 2.18 is just quite a good document to have open for that purpose, because I think Mrs. Beaumont's been referring to certain aspects of that when in her descriptions, if I've got that right.
Okay. Is there anything else you want to say about mitigation strategy?
And I think in general, a significant amount of open space is going to be provided within the site, particularly to the southeast of the site, which is an area of the neutral grassland that's proposed, or meadow planting, with scrapes. That is adjacent to the reptile receptor site that's been proposed. So, yes, that area of bramble scrub will be lost, but the area of open space that's proposed within the site is far greater than the area of habitat that's proposed to be lost. And in terms of other species present there, you know, the mitigation that can be provided is relatively straightforward in terms of nesting birds, which are only protected during the nesting season. You would look to avoid removal of that vegetation during the nesting season. Chetty's warbler was identified within the site as a breeding species. Well, it was recorded as a probable breeder, one pair within the site, within that area of scrub, and another pair within the buffer adjacent to the water bodies to the north of the site. The breeding bird report that was provided again as an appendix to the ECIA document has identified the breeding bird assemblage as being of local importance in terms of the site and the surrounding buffer. In terms of the site itself, it probably falls below of local importance. And that is based on an established methodology for assessing the value of species assemblages.
Okay, any further comments from this side? Okay, thank you. So we're happy to move on to the off-site effects, the Ramsar effects. Is that Mr. Cook, are you leading on that more than Ms. Beaumont?
Well, basically, there hasn't been an off-site survey or assessment of the impact of the proposal. Sorry. So there's been no survey done. And that is clear. It's been marked up on TEP drawings as not having been surveyed. In the initial report they put in, I think there was about 2 lines, possibly 3 lines, covering impact from the discharge, where it just said there won't be any pollution, there won't be any sediment because of it's going to be designed out, which is wishful thinking. You can't design that out. You can put petrol interceptors and the like in. You can put type 1 petrol interceptors rather than type 2 to get the most effective, efficient use. But even with those, it comes down to maintenance. They have to be emptied. They should be emptied every 3 months to get proper efficiency. Usually they're not emptied more than once a year, and all that would need to be covered by condition, who's going to actually be in charge of the drainage if this scheme goes ahead. So you are likely to get petrochemicals, also sediment. There was reference in the TEP documents to standing water in the attenuation lagoon. You can't possibly get standing water in the attenuation lagoon. But if you did with plants, etc., as they were suggested, then clearly you would get sediment because you'd have turbulent water as water would continue going in and coming out, and that would take sediment with it. You'll get sediment coming through the traps in the petrol interceptors, again, unless they're cleaned out very frequently. So you can expect there to be some pollution, you can expect there to be some sediment, and also because it's how they do it, there are levels problems. I've highlighted the fact that within the site you've got levels differentials. If you're at the bottom part of the site and you're trying to fall at and you have to fall at a minimum 1 in 100 towards the top lagoon, by the time you get there some 250-300 meters away, assuming it's just a single point and not circular, you're going to need to pump to get into it because you have to go in at a high level, whereas the outlet is at a low level. The volume that they have indicated in the drainage strategy basically is the volume that is needed for the event that it's designed for. So for that to work, you've got to have the outlet at the bottom, otherwise the whole of the storage isn't available as storage. If you're getting standing water occurring below the outlet, then it's only the area above the outlet that is there for attenuation. So, for example, you have the attenuation down by 1/3. You're only attenuating by 1/3 of the volume of the whole thing. So that's an issue. The rate of discharge, it would take continuous discharge. It would take several days for the attenuation storage. So you'd have several days of water continuously flowing into the ditch. The impact of that hasn't been assessed. There's all sorts of freshwater springs and ponds and habitats downstream. It said in statement that the Lower Medway Drainage Board has approved the proposal. Actually, they said they had no objection in principle, but they said what happens downstream, and that question's never been answered. And the point is that downstream is where you have the ponds. It's also where you have the ditches, such as the one that they want to discharge into, narrowing down into small bore pipes because you've got effective to create culverts, so that you've got the area above covered in earth, so that cattle can go over it, vehicles can go over it, etc. So it's not just a collection of open ditches and streams and ponds. It's more than that. Obviously that will still has to be assessed from the drainage point of view, but that's a separate subject. But from the ecological point of view, nobody's looked to see what habitats may be affected, what plants there might be, and the area would need, again, because of levels and things, you'd need to end up with head walls. You'd probably need to have some form of storage because of the difference in levels, because you'd have to get the water level up from where it's being piped out along from the lagoon up. The lagoon would probably would undoubtedly have to be reinforced concrete. You couldn't have a membrane, which is suggested by the fact they're talking about battered sites, etc., because the headwater levels are such that it would just lift it up. If you visit the site, you'll see the quarries around that have filled up with water from the high water table, so the water level is very high. It's why you've got lots of springs in the marshes area, freshwater springs. What would happen if you dig a hole? The hole would start filling with water as you dig it, and then if you try and succeed in lining it, that lining would just lift up because of pressure of the water coming in from underneath, and it would end up floating on it, and you'd end up not having an attenuation storage. So you'd have to have a waterproof form of doing it. The normal way of producing attenuation storage is to have underground tanks. Prefabricated, they come in, you dig a hole, you stick them in there, you connect them all up to get your desired volume, and you go from that. The open water aspects that you tend to get with drainage systems is where you're getting longer term storage, and that's where you might get standing water and the like, but that's not what is currently within the proposal. So there's all sorts of issues with that's not been explored, and the impact of it on the Ramsar hasn't been explored. And it may be, you can say, okay, it's one outlet. And I mean, the design of it, I mean, the principle of SUDS is that you're reducing the discharge rate to the discharge rate of the greenfield site. But at the moment, the greenfield site is discharging over a boundary of a couple of kilometres. And now it's going to be discharging at a single point if this proposal goes through, and some form of agreement could be reached with the Brays, who are adamant that they don't want it, and I've told them they could get a lot of money if they went ahead with it, and they said we're not interested. There is an issue. So you're taking all the water from one point. It is a material change. It's a material intensification, which we will come on to on other arguments that will be raised. But that is having an impact on that single point. And you need to then also consider things like the erosion that will take place. And it's one of the reasons why you start talking about head walls. But they can't have a head wall on the Brays land there. They could have a head wall further back. They don't have the right to put one within the Ramsar area. That wasn't part of any agreement, and they need consent to do that. But if you don't put things like that in, erosion's going to take place. So it'll have an impact. It needs to be measured, and somebody needs to assess it. It may not affect ecology, but it could do, because you are likely to get petrochemicals, you are likely to get sediment.
Okay. Mr. Newell, your thoughts there, please.
Yes, well, I mean, there's quite a lot to unpack there. I think I'd start by saying that as an ecologist, I really can't comment on the design of SUDS or the technical aspects of how the SUDS will operate. However, SUDS is an established method for dealing with runoff from sites. It's incorporated into most developments these days, and I've got no reason to believe that a SUDS compliant stream is not possible. And as stated in my evidence, the assessments have been based on the assumption that the scheme would be SUDS compliant. In terms of not undertaking surveys of the Ramsar and SPA, I think the value and the makeup of those habitats and the species they support is very well documented in the citations for those sites. We didn't go and survey them specifically, other than for the ornithological surveys, which took in the areas of the SPA and Ramsar within a 500-metre buffer of the sites. But no, there were no habitat surveys undertaken within the designated sites. I mean, I have been, the outline drainage strategy that was provided set out, I believe, that the rate of discharge would be at greenfield rate. Again, I've got no reason to doubt that will be the case. In terms of it being a single point of discharge, I think that is probably accurate, but there are certainly ways to moderate the rate of discharge from a head wall like that. So I don't see a reason why we would assume there's going to be an impact there, but the detailed design of that SUD strategy will be dealt with by a condition, which is a fairly standard way of dealing with drainage design, and that condition can also incorporate any monitoring required of that strategy. But again, we're kind of getting out of ecology issues there. I'd also note that the habitats regulations, the shadow habitat regulations assessment that was produced by TEP, which is CD 2.6, did take into consideration contamination of water from both construction phase and operational phase impacts. They were taken on to stage 2, the appropriate assessment stage, and the shadow habitats regulations assessment concluded that those impacts could be mitigated, mainly via a SUD strategy, amongst other things. So again, that assessment does fall back on the assumption that the SUD strategy will be effective. With regards to the habitats regulations assessment that was produced, the Kent County Council Biodiversity Officer, who was providing expert ecological advice to Swell Borough Council, commented in CD 4.16 that they'd reviewed the appropriate assessment and advise that they are satisfied with the conclusion that the proposal will not result in an adverse impact on the designated sites if the proposed mitigation measures are implemented, and went on to propose that the shadow habitats regulations assessment was adopted by the local planning authority. Clearly, they were the competent authority at the application stage. You will be the competent authority in context of the inquiry, so I'm sure you'll come to your own conclusions on that document.
Mr. Cook?
Well, we'd still come back to the fact that no survey has been undertaken, habitats haven't been assessed. It's basically it is a requirement of the MPPF that happens. I find it astonishing that it hasn't happened. To start trying to pass the buck to other people outside and say, well, you know, it's all very well, but the MPPF says, I think it's 188, you know, you've got to do an assessment. They haven't done one. And I wasn't trying to talk about the drainage as in criticising the drainage, just saying that what's being proposed will not eradicate petrochemical discharge, oil discharge. It cannot do it in its entirety. There will always be some, but they can go for best practice. But there are different practices. You've basically got two sorts. One where you're going to be talking about something like 5 milligrams of pollutant, and the other where it's 100. So there is a difference, but it also, what do you do round the site? If you don't get the maintenance, you're going to get issues. And that's beyond question. And, you know, Gladman cannot say what will happen because they will not be in control. They are not developers. So they will not be building this out. You know, who will and what will they do? If consent is going to be given for this proposal, then the condition needs to be very strict with respect to saying, look, you've got to do it. But my concern is that if this appeal is approved now, we're approving it. We're approving the principle of discharging into the Ramsar without actually there having been an assessment to see whether that's acceptable either from an ecological point of view or from a drainage point of view, which the latter being an argument for another day. I think that's a very dangerous thing to do, because once you've approved the principle, it's very difficult to start rowing back on that when people start putting in applications for approval of reserved matters.
Okay, thank you. Mr. Lane?
I just wanted to pick up a point in relation to that, because Mr. Cook's referring, when he says there hasn't been an assessment, and refers to paragraph 188 of the framework. So, as you all know, that's referring to the appropriate assessment in the context of the protection of European sites. It's not referring to an ecological assessment as such of the site. And in this case, the drainage strategy is not being put forward for approval by you at this stage. An outline drainage strategy has been presented, and it's been referred to and relied upon in, amongst other places, the shadow appropriate assessment, and it also formed the basis upon which the application was consulted upon with the relevant consultees. The upshot of that in relation to the position of the council, as was the competent authority at 4.10 of the Statement of Common Ground, it's agreed that subject to the proposed mitigation measures, there would not be any adverse impact on the integrity of designated sites. And the measures set out in the shadow appropriate assessment and by reference to the outline drainage strategy that secure that, i.e. controlling the rate of runoff and ensuring that it's filtered and monitored and managed, all of those you'll have seen are the subject of conditions, draft conditions that are put forward, many of which have been proposed by the statutory consultees to ensure that they're effective to secure the strategy that's been put forward in outline.
Okay, thank you. Any final thoughts on this, Mr. Cook? Oh, sorry, Ms. Beaumont.
Yes, going back to ecology again. Yes, there are at least 5 quite rare plants on those sites, on the marshland sites there. And don't forget, it's also a cattle grazing site, so it's very important there's no pollution there. I mean, you can imagine the problems of animals getting sick because of the pollution. So I think we do really need very strict controls and also a proper assessment of the site beforehand, because otherwise how do you know if it's been degraded or not?
Thank you. And Mr. Cook, did you have anything further?
Yes, my interpretation of 188 wasn't the same as Mr. Williams. It does say that maybe...
Can you put your mic on, please? Sorry.
Beg your pardon. Yes, my reading of 188 says the presumption in favour of sustainable development does not apply where the plan or project is likely to have a significant effect on a habitat site, either alone or in combination with other plans or projects, unless an appropriate assessment has concluded that the plan or project will not adversely affect the integrity of the habitat site. So it's talking about specific individual projects, so such as this. So I think that 188 does apply, and an assessment should have been carried out.
Okay, I think, well, that's for me to, I think, consider as decision maker. Thank you.
Okay.
Thank you, everyone. Ms. Beaumont, the aquifer.
Oh, yes, thank you. Yes, I'm surprised nobody else has actually raised this, to be honest. The aquifer is very deep, and it comes from, I'm not quite sure where, Europe, I think, and it goes underneath Faversham, has springs popping up and wells popping up all over the place from it. And as I said earlier, it's being used by the breweries. That's why the breweries are there in Faversham. And it flows under that site, as I understand it, onto the Ramsar site. So it's important for the freshwater lakes. It goes in, feeds those freshwater lakes, and also a public it's tap, a public fountain, so you can go down there and people go and collect their water, get their water bottles full. It's such lovely water. So if that becomes polluted by the building work that goes on without some due regard to protecting it, I mean, that has a very serious ecological impact on the area. That's why I wanted to raise that issue.
Mr. Newell?
I'd have to say that the impacts on the aquifer are outside of my area of expertise, so I can't comment on that, I'm afraid. But during the construction phase, we have proposed that a construction environmental management plan would be put in place, secured by way of a condition. Again, it's a very standard condition to apply, which would look to mitigate any construction phase impacts. But as I said, in terms of impacts on the aquifer, it's not something I can really comment on.
Can anyone in the Appellant's team?
Hopefully I can help, sir. So obviously the site has a recent history of gravel working. Perhaps when you were walking around the site you saw a number of standpipes on the site. It's currently in closure, and they are actively monitoring under the terms of their permit groundwater contamination from that actual activity. and they have to supply that to the Environment Agency. So groundwater contamination is already being monitored on the site, and then as per the my Appendix 3 to my proof and the Phase 1 ground investigation, there will have to be an intrusive survey subject to conditions and development in accordance with that to ensure that there is no contamination of groundwater or the environment.
Okay, thank you. Mr. Cook.
The most inexpensive way to develop the site would be to use a system of infiltration where they had soakways and the like, and I was very surprised to see that they weren't using that until I realised that we were talking about land that had contamination issues. So what they've done is they are going for the suds because they're collecting the water discharge and they're taking it off site, and I think that one of the conditions says that there shall be no infiltration. If there is no infiltration, then there won't be a problem. Obviously that's one of the issues I have with the drainage study, because it's talking about swales which involve infiltration, so that's a contradiction. But providing an appropriate scheme were to be designed, sud scheme were to be designed, there shouldn't be an aquifer problem. But and so long as there is ongoing maintenance of the system.
My concern is if there's any pile driving or any, because there's such a lot of work planned for this site with digging and raising the levels, and obviously you have to anchor those houses down as well. So the pile driving has been an issue in the area already, and I think that must be very, very clear that that's not allowed on this site, because that could fracture the chalk, as I understand it, and then you get the pollution which is already there. The whole area is full of rubbish. It's going to drain down into it, and that's where I feel we need to just be very well aware of that. I'm not a technical person about this, but it's just a gut feeling that there's something really wrong about pile driving through rubbish into chalk, under which there is this beautiful aquifer. That's my concern.
Yes, well, that comes down to conditions. I mean, obviously, pile driving does cause issues. CFA, continuous flight auger, is a better way of doing it, and it's something that we've used extensively. My practice has used extensively in the past. It's very rare that we would go for piles where other buildings were around, because you're likely to cause problems in those other buildings and cause expenses. So I would have thought it was unlikely here. It also it is possible for them to sort of cap. So providing the right conditions are applied, then it need not be a problem. But I would agree with Ms Beaumont that there should be some form of condition with respect to how that is carried out.
Okay. BNG. I'll start with the appellant this time. So just really an outline for your approach to this, please.
The approach to the biodiversity net gain assessments.
Yes.
Yes. Well.
What do you think the result's going to be, and why do you think it'll work?
Yeah. So yes, we undertook a BNG feasibility assessment. Obviously, it was a feasibility assessment because it's at the outline stage, so it was based on a fairly high-level master plan. The BNG methodology is well established and well understood by most. You look at the baseline habitats present, the strategic significance of those habitats, the condition of those habitats, the distinctiveness of those habitats. You apply a value to those habitats, and then you look at the post-development habitats that are going to be present, and it's effectively a balance sheet exercise whereby you look at habitat loss, habitat retention, habitat enhancement, and habitat creation. So we have undertaken the BNG feasibility assessment that was provided as CD 2.2. And that demonstrates that in purely area-based habitats, through on-site measures, the proposal is capable of achieving a net gain of 6.89 area-based habitat units, and that's a 22.94% biodiversity net gain. We're able to do that because, as I mentioned previously, when you take a step back and you look at the habitats present, they're of low intrinsic ecological value. I mean, largely the habitat loss is arable lands, which is low distinctiveness habitat, and that will be replaced by a significant area of open space, which will include areas of scrub, areas of hedgerow, wetland scrapes, areas of moderate distinctiveness grassland.
Okay, thank you. Is there any comments on this from either the council or the Royal Six Parties?
No, I mean, the only thing that's disappointing is the fact that the figures and calculations aren't in there. You end up with a conclusion, but you don't actually see what's going into arriving at that conclusion, and therefore it's difficult, without having done the exercise yourself separately, it's difficult to repudiate. It would have been a lot better when we've got them. It does seem to me, looking at it, as though very little weight has been given to the wildlife corridor that we've been talking about, that's flagged up in the Faversham neighbourhood plan. But given the lack of information, I can't really pass comment.
Yes, Mr. Lane.
Thank you, sir. Just one point that Mr. Cook has kindly reminded me about, the Faversham neighbourhood plan. Now that's in play, Fav 7 criterion 2 requires not just 10% biodiversity net gain, but 20%. So it's just to take into account Mr. Newell's point that the site can achieve that and exceed it.
I'd also like to go in, if I can, and just say that the metric was available on the planning portal. It was part of the documents that were submitted with the application, so it is freely available to download and look at. I'd be happy to forward it on. And in terms of the value of the wildlife corridor as it's described, biodiversity net gain is a process that uses habitats as a proxy for biodiversity gain. So it looks at the habitats themselves rather than the value of those habitats for particular species. So it's a distinct assessment process. That the value of that area of habitat for additional species was assessed within the ecological impact assessments.
Okay, thank you. Do we also need to cover land ownership, or is that not really linked to this, Mr. Cook?
Sorry?
Does land ownership overlap with ecology?
No. But that's a minor point, so it's not really worth.
Is there anything you want to say to that before, just while Mr. Cook's?
I was going to say that my understanding is that the area of land that's being referred to there is not within the ownership of the Rowe brothers. It's their tenant land, which is an annual agreement, and any habitat shown for habitat creation within the red line boundary is freely available and is owned by the landowner rather than the Brays. But that's not really an ecology issue, the land ownership, but that's my understanding.
Okay.
Well, I have a land registry plan available that would show that that's not the case.
Well, will we be coming back to this? Yes, okay. We'll leave that till then. Okay, any final comments on ecology?
I wonder, the document that was admitted this morning, provided by Mr. Cook, I wonder if it might be worthwhile just clearing up a couple of misinterpretations for your benefit if you're reading that document.
Please just give me a moment to load this up. Okay, please go ahead, Mr. Newell.
Thank you. So in the first paragraph, which is 2.1.2, Mr. Cook makes the point that he's disappointed that the area of scrub habitat along the southern boundary of the site hasn't been included as priority habitat. I think there's a misinterpretation there of what priority habitat is. Priority habitat or habitats of principal importance are those habitats listed under Section 41 of the Natural Environment and Rural Communities Act. So hedgerow is included as a priority habitat, but scrub, particularly bramble scrub, isn't a priority habitat in that context. So I just wanted to clear that up. Also, there was a reference to the species-rich hedgerow along Ham Road. It's not entirely a species-rich hedgerow. There are sections of that are species-rich. But again, Mr. Cook made the point, why is the area of scrub not described as species-rich? Again, it's a technical point. When I'm referring to a species-rich hedgerow, that is a specific description of a hedgerow that contains a minimum of 5 woody species within a certain extent. So again, it's just a technical point to clarify there.
Okay, thank you. Okay, any final comments? In that case, thank you very much. And that brings us to the close of proceedings for today as well. In terms of ID documents, I have the 2 openings as ID1 and ID2 by the appellant and the council. Ms. Bowen and Mr. Cook, have you or will you be sending in electronic versions of your opening statements as well?
Yes.
Okay. Sometimes it takes a while sometimes to come through our system because it goes through my case officer. So.
I sent it to Wigan and asked him to.
Okay. And then, so ID3, I've made your comments, Mr. Cook, the ones that we just discussed about biodiversity. And then we'll call ID4 and 5 your 2 opening statements as they come in. And if we need to pick up anything else, then we can do it in the morning. Anything from anybody else before we close for the day?
So can we just raise a subject that my learned friend and I have been talking about on and off, about timetabling, just to get your instinctive view.
Okay.
There's been a statement this morning sent about the timing of the NPPF from the department to local planning authorities, saying that it will be out later this week. So it does seem that, with growing certainty, that it will be this week. And we basically think that it would be worth doing some contingency planning, because it seems far from ideal to start the oral planning evidence if it's going to have to be paused or adjourned. And that seems now to be pretty likely. And so we didn't know, sir, whether you might want to think about bringing forward conditions 106 site visit to the time on Thursday, Friday. And then future planning, I think we'd have to do once we'd seen the NPPF as to whether it's achievable to do that Tuesday, Wednesday, or whether the changes mean that we need a longer adjournment.
Okay, so that does seem... I'm looking at the schedule in front of me. So we'd be doing flooding tomorrow, because that's technical. And then it sounds to me like we'd like to get through that in one day as well, based on what you've all been commenting about. And then Thursday would be conditions 106 and site visit. Is that... Or maybe Thursday would be conditions 106.
We may not finish flooding. I don't know.
Okay.
And it seems worth pressing ahead with flooding, even though there may be some changes through the PPG. We just don't know. But if we saw flooding through to its completion, whether that's tomorrow or Thursday, we could then go on to conditions 106. And if that enabled you to do the site visit on Thursday, then that would presumably be better from your point of view. But it will be dark, obviously, by
That's a good point.
3:30.
But it feels like we could do flooding 106 in this order: flooding, conditions 106, then site visit, and it feels like we should be able to finish that by the end of the week.
Definitely, yes.
And then, as you say, we can take a view as to. There's no point really speculating about. It might be that we can do the planning witnesses on Tuesday and Wednesday,
Yeah.
but it might not be, and then we just have to think about what kind of adjournment we need.
Would the plan then be for closings to be virtual or in writing?
I would say it would have to be virtual in writing, because otherwise it'd be unfair to have planning witnesses followed directly by closings.
Yes. Well, that would certainly be.
It might also be tight on time.
Yeah.
Yeah. The only thing that I just flag is that obviously we've got Rule 6 parties, which does make it more likely that more time will be needed to digest the relevant provisions of the MPPF and potentially to take legal advice on what any changes mean. So I'm reluctant, just from a fairness perspective, just to push on. I mean, Mr. Carpenter might be up for taking the planning evidence on the hoof and updating it very easily, but I wouldn't necessarily like to say that would be an appropriate approach, bearing in mind we've got the Rule 6 parties here.
Yes, but I mean, it just depends on the nature of the changes, doesn't it? Because if the changes don't really go to the meat of this inquiry, then there shouldn't really need to be that many changes. So I think for now we just don't really decide either way, but please be rest assured that I will be making sure that nobody is disadvantaged in any decision we make. So, yeah, so flooding, the 3 flooding, conditions 106 site visit, that's this week. And then we'll decide what to do with the planning once the frameworks come out. Okay. All right, thank you very much. We're starting at 9:30 tomorrow. Okay, thank you. The inquiry is